all these last two lines पढ़ लीजिए।
जी बता रहा हूँ। One subservient to the legislature in a fashion that in rendered subservient by legislature well what then is the meaning of subject by law. Only what then is the meaning of subject by law. Only interpretation of subject law that will not make the system and integrate at the same time of rational and at the same time equivalent of surveillance power as in all the legislation between substantive defines our rights held in the legislation between substantive defines our rights with such rights in the age 147 is a fundamental one such rights in the age 147 substantive law that is much more than the judge may amend the rules substantive law and essential rights that the judge may amend the rights and essential rights substantive law outside the subject of other the phrase substantive law and the reason remain the same in the process of setting them as not reasoning and the same in the process of examine the mind and while the court yes is subject to the subject to the decision while the court yes is subject to the substantive law wholesale to the they are not to make substantive law wholesale subject to law rule making power does not give the concept power subject to law it is not subject to legislation where it is made subject it is not subject to legislation where it is made subject to legislation then makes constitution uses the word ये कई articles हैं of the constitution and 154 ये कई articles हैं of the constitution and 144 241 and then 142 के अंदर भी 241 and 242 के अंदर भी यही लफ्ज हुआ है
dispute has been made pursuant to Article 175 dispute has been made pursuant to Article 175 so in the law itself pursuant to Article 175 in the law itself pursuant to Article 175 we are read with utmost time on 191 we are Article 175 on 191 no court has jurisdiction unless conferred by the Constitution no court has jurisdiction unless conferred by the Constitution of the law but no it is dedicated to it is the power of the court the judicature the power of the court the law that have made and pursuant to the law that has been made the law has been made pursuant to Article 191 but the law has been made में आपने jurisdiction किसी कोर्ट का पढ़े ना में आपके jurisdiction किसी कोर्ट का jurisdiction में 100
इसका मतलब ये प्रोविंशियल लॉ सही है आपके लिए प्रोविजन बना सकते हैं लॉ भी आपके लिए प्रोविजन बना सकते हैं
कोर्ट ऑफ पाकिस्तान 174 for each shall be a supreme court of Pakistan for each province
in no such may be established by law no court shall have any jurisdiction save as is or no court shall have any jurisdiction by under as or may be conferred on it by constitution by under submission or under any law that is synonymous this honorable court has interpreted it when it deals with the Supreme Court has it has to be read with two further articles article 142 it has to be read with two further articles article 142 and 50 and that is the judgment of article 142A and that is the judgment of this honorable court sir understand
this
article, sir.
Article is, I don't understand.
No,
article, sir. You are now reading words into the Constitution. No, where does it say it's not a standalone words into the Constitution? So you can imply it's not a standalone article.
Because the judgment of
so you can imply it, but it doesn't say
arguments. I'm not saying anything of my own. I'm citing my argument of this law and what they have said. I'm citing case law on that of this
object
what they have said.
Hearing counsel is being missed. If all we are going to do hearing counsel is being missed, case words is going to do then you want to read your gravity of it sitting. I don't even understand the gravity of counsel. To refer to understand, refer to learn from the Supreme Court. Let's refer to that judgment. You don't want to read plain words. Then you want to read new judges Supreme Court. You don't want to read plain words. Then you want to read new judges Supreme Court. Let's reformulate versions on that.
में भी सेम यही हुआ था।
पापा अम्मी घर पे नहीं है पप्पू है कि बस 92 के वर्ल्ड कप में फंसे हुए हैं मेरे पेट में चूहे रंज ले रहे हैं क्या करूं
पापा
conferred on it by constitution by under any law. So the only two articles of the constitution when it concerns the honorable Supreme Court is article.
ये बार आप honorable Supreme Court नहीं होता है Supreme Court ऑनरेबल जजेस होते हैं अंग्रेजी का तो सही इस्तेमाल कर लेना ऑनरेबल पार्लियामेंट नहीं कहते
ये भी आप भी करते हैं ہم یہی کرتے ہوئے آ رہے ہیں سر.
چلے آگے ذرا پوائنٹ
جی
بتائیں نا آگے.
my humble submission is that article 175(2)
جی
has to be read with
آپ نے کہا has to be read with
article 142A and entry 55.
142A and entry 55. Let's read 142A.
Mr. Zubairi, the point it seems to me over here is the question that when we are talking Article 191, we are talking of practice and procedure.
Ji.
Are we really talking of the jurisdiction of the court?
No.
We are talking of a direct grant by the Constitution
Of the regulation.
of rule-making power with regard to practice and procedure.
Yes.
So, when in this act, in the preamble, when reference is made to Article 175(2), which relates to jurisdiction,
Well on.
is
Then you go
that
to
be-
142A.
What is, would that be correct, or would that perhaps be not entirely correct? Because here we are not talking of the jurisdiction of the court, but of its practice and procedure.
بالکل سر.
حبیب صاحب اس قانون نے ایک اور کام بھی تو کیا ہے. اس قانون نے ایک اپیل کا حق بھی تو دیا ہے, تو وہ پروسیجر میں تو نہیں آ سکتا ہے نا. تو وہ صرف 175 میرے ذہنیت کے مطابق وہ صرف 175(2) ہی میں آ سکتا ہے. اس کو پروسیجر میٹر ہم نہیں سمجھیں گے.
وہ بھی ایک جوریڈکشنل پوائنٹ ہے, وہ 142A اور اینٹری 55 کے تحت آپ کو پڑھنا ہوگا.
بتا دیں ہمیں.
جی 142A دیکھیں سر. Because they are not the word 175.
پڑھ لیجئے.
جی 175 talks about jurisdiction. 142A sir.
آپ شروع سے پڑھیے 142. یہاں بھی سبجیکٹ ٹو دا کانسٹیٹیوشن لکھا ہوا ہے.
میں آ رہا ہوں سر. سبجیکٹ ٹو کانسٹیٹیوشن. مجلس شورا shall have
نہیں اوپر سبجیکٹ ٹو دا کانسٹیٹیوشن.
جی
اب اس کا بتائیں اس کا کیا مطلب ہے.
The constitution is subject to it. It cannot be any law cannot be in violation of any constitutional provision, existing provisions of the constitution, sir. Majlis Shura Parliament shall have exclusive power to make laws with respect to any matter in the federal legislative list. So this power to make law, exclusive power to make laws, as provided in federal legislative list, sir. And now entry 55.
ہم یہاں پہ انٹینشن آف دی لا میکر اور کانسٹیٹیوشن میکر دیکھ رہے ہیں. آپ کہتے ہیں کہ رولز بنانے کا اختیار دیا گیا ہے اور صرف لا کے تحت نہیں ہوگا جو آلریڈی ایگزسٹنگ لا ہوگی. اگر آپ انٹینشن آف پارلیمنٹ دیکھنا چاہتے ہیں تو آپ آرٹیکل 175A سب آرٹیکل 5 دیکھ لیں.
جی
سب 4.
جی
یہاں پہ سبجیکٹ ٹو کانسٹیٹیوشن اور لا نہیں ہے.
جی سر.
The commission may make rules regulating its procedure.
جی
اگر انٹینشن کانسٹیٹیوشن میکر کا یہ ہے کہ وہاں تو سبجیکٹ ٹو کانسٹیٹیوشن اینڈ لا ہونا چاہیے, تو یہاں کیوں نہیں دیا گیا سبجیکٹ ٹو کانسٹیٹیوشن؟
Because humble submission is that
ذرا پڑھ لیں.
جی I'm reading it.
175A.
The commission may make rules regulating its procedure. Sir,
یہاں تو سبجیکٹ کانسٹیٹیوشن نہیں ہے.
سر آپ نے تو
اس سے انٹینشن آپ کیا کریں گے؟
فل کورٹ نے تو سپریم جوڈیشل کاؤنسل کی رول میکنگ پر رول کی کوئی پروویژن نہیں, اس پہ بھی کہا ہے they can make rules, the supreme judicial council can make rules which will have constitutional status. یہ ہے judgment of the
یہاں پہ
honorable.
میرا سوال شاید میں نہیں سمجھا پا
جی میں آپ سمجھ گئے, آپ کہہ رہے ہیں
ہمیں انٹینشن دیکھنا ہے.
جی
یہاں پہ تو یہ کہا ہے without mentioning the word subject to constitution law.
جی
یہاں سمپل کہا ہے the commission may make rules.
جی
اس سے تو بات سمجھ آتی ہے کہ آپ نے رول لا کو نہیں دیکھنا جو ایگزسٹنگ ہے یا پہلے سے ہے.
جی
وہاں پہ یہ دیا گیا ہے کہ سبجیکٹ ٹو کانسٹیٹیوشن, یہ تو انڈرسٹوڈ ہے کہ سبجیکٹ ٹو کا مطلب ہے اس کے تابع ہونے چاہیے.
جی
عموماً ہوتا بھی یہ ہے کہ پہلے پہلے ایکٹ بنتا ہے اس کے بعد رول بنتا ہے.
جی
رول کبھی ایکٹ سے اوپر نہیں ہوتا ہے, نہ ایکٹ سے ہٹ کر ہوتے ہیں. کوئی بھی رول اگر بنایا جائے وہ ایکٹ سے, ایکٹ کے ڈومین سے یا کانسٹیٹیوشن کے ڈومین سے باہر ہوں گے تو اسٹیک ڈاؤن ہوں گے. تو یہاں تو یہ ذرا بتا دیں کہ انٹینشن واضح نہیں ہے دونوں آرٹیکلز میں.
سر اس میں میرا humble submission will be that in this case sir still no rule can be made in violation of the constitutional provision.
اب آپ جی سوال کا جواب یا تو سوال نہیں سمجھے, میں آپ لیے آسان طریقے سے بتا دیتا ہوں. مائی لارڈ پوچھ رہے ہیں آپ سے کہ جہاں تک جوڈیشل کمیشن آف پاکستان کا وہاں نہ سبجیکٹ ٹو لا ہے نہ سبجیکٹ ٹو کانسٹیٹیوشن ہے. اس کا مطلب ایک مطلب تو یہ نکلتا ہے کہ نہ کوئی لا بن ہی نہیں سکتا ہے اس کے متعلق, وہ ہمیشہ کمیشن خود ہی بنائے گا اپنے رولز. یہ سمپل ریڈنگ ہے. جی اور وہاں 191 میں سبجیکٹ ٹو لا اینڈ کانسٹیٹیوشن اس لیے لکھ دیا گیا کہ آئین میں بھی ہو سکتا ہے اور لا میں بھی ہو سکتا ہے. تو یہ ان جمال صاحب کی انڈرسٹینڈنگ غلط ہے تو ذرا سمجھا دیجیے.
بالکل صحیح. میں جو عرض کر رہا ہوں کہ جہاں سبجیکٹ ٹو یوز ہوتا ہے ورڈ, وہاں آلریڈی کا کوئی رول اس کے وائلیشن میں نہیں بن سکتا. which is already existing, subject to constitution, subject to law, already substantive law exist करता है, उसमें आपकी regulation और practice and procedure पे आप फिर इसमें अगर नहीं यूज किया गया तो इसका मतलब ये इसको सब्जेक्ट ताबे नहीं किया जा रहा है।
ठीक है, ये आपका इंटरप्रिटेशन
जी, इसको ताबे नहीं किया जा रहा है, but still no rule can be made in violation of the constitutional provision or any law।
ठीक
जी,
Mr. Zubairi,
Malo.
so that it is the only Supreme Court which can make rules under Article 199. High Court and Federal Shariat Court, they are having the same powers.
So 202 of the Constitution gives the power to make rules to the High Court, sir.
And is there any law made for those two courts?
उनके अपना procedural laws हैं High Court में, and that judgment of a single bench judgment was cited by Mr. Bhandari on the last date, 2021 Lahore, which deals with what is the meaning that rules can be made, but they are no, they have to be read with the anti 55 does not apply to them, because that's why the rules of law reforms ordinance की बात की थी।
Parliament has put up clog on the Supreme Court. Why not on High Court and the Federal Shariat Court?
The High Court में है
What were those
202
special
sir.
reasons to constitute this act?
Sir, 202 kindly be seen. Subject to constitution and law, a High Court may make rules regulating the practice and procedure or of any court subordinate to it. So 202 is
203J is the
जी,
Federal Shariat Court.
जी, 203J।
नहीं, आप माय लॉर्ड का सवाल नहीं समझे। आपका पहले वाले सवाल का जवाब ये था क्योंकि रूल्स बन गए हैं तो अब सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ has been rendered effectively meaningless. माय लॉर्ड का सवाल ये है, अगर आपकी ये बात सही है तो सुप्रीम हाई कोर्ट के कौन से रूल्स और फेडरल शरीयत कोर्ट के कौन से रूल्स बन गए थे, ये फिर इसका जवाब क्या होगा? ये मैं इसका जवाब आपने नहीं दिया।
सर, पहले मैं आपकी बात का वो जवाब दे दूं।
नहीं, मैंने सवाल नहीं पूछा, मैं सिर्फ आपको माय लॉर्ड का सवाल बता रहा हूं।
आपने कहा कि अब नहीं, मैं अभी भी कहता हूं, आज आप रूल्स बनाने जाएं, they cannot be in violation of the constitution, subject, they have to be subject to any substantive law।
I can only use one word for it, profound।
जी, but still आपने ये कहा कि मैं कह रहा हूं कि जी अब नहीं हो सकता। my lord, rule making power is a continuous power।
के समझ, मगर माय लॉर्ड का जवाब नहीं दिया आपने।
जी, मैं दे रहा हूं उस पे सर। इसके अंदर भी जो लॉ उन्होंने बनाया है, that has to be subject to constitution and the law, and that is the interpretation given in the judgment of।
इसके लिए तो कोई legislation
the Lahore High Court in a full bench judgment, जब ये क्वेश्चन अराइज हुआ था कि गवर्नमेंट ने भी लेजिस्लेशन कर दी थी और हाई कोर्ट ने रूल्स भी बना दिए थे, the High Court said you cannot do that।
जी।
Helping others is at the heart of everything I do. WCTC has given me the tools to help make our community a better place.
I knew I wanted a career, but I didn't know where to start. WCTC offered me nearly 100 different programs to choose from.
I thought earning a degree would put my life on hold. At WCTC, I found a balance that works for me.
Your journey.
Your journey.
Your journey.
Your journey starts at step 1. Enroll today at Waukesha County Technical College.
GB and unlimited network minute, and get your SIM delivered at your doorstep free of cost. On it.
जी, बुकलेट में नहीं है सर, मेरे नोट्स भी हैं, मैंने अपनी CMA भी दाखिल की हुई है, पर क्योंकि माय लॉर्ड ने पूछा तो इसलिए मैं निकाल के पैरा 61 और बात 202 पहले कोट करते हैं और फिर मैं आई रीड दिस पैराग्राफ सर।
ये पेज 544 आप
580 सर, it starts at page 544 and relevant portion which my lord's observation is at page 580।
सिंगल बेंच का जजमेंट है
जी।
Why you are citing it before full bench?
तो इसमें इंटरप्रेट हुआ है हाई कोर्ट की पावर्स के ऊपर जो 202 की पावर्स हैं। जी,
सिंगल बेंच का जजमेंट फुल कोर्ट को फर्क पड़ता है क्यों नहीं पड़ता?
इसमें एक लॉ बना दिया था, अमेंडमेंट लॉ, और रूल्स में अमेंडमेंट कर दी थी। दैट वाज चैलेंज एंड दैट वाज सेट असाइड। काइंडली may I read with lordship's kind permission?
You want to?
जी। Thus the High Court have been conferred the constitutional power regarding rules and procedure, which may not only regulate the practice and procedure of a High Court, but also any court subject to it. In exercise of this power, HC has made rules entitled High Court Rules and Orders, which contains elaborate procedure to be followed by the court subordinate to it in matters relating to adjudication of cases before civil court. Thus, not only has the High Court been delegated the power of making and amending rules in the first schedule by the court itself, but also by the Constitution by virtue of Article 202. The central question regarding power of High Court has escaped the attention of Government of Punjab while promulgating the amendment ordinance which impinges upon the powers of Lahore High Court to enact and amend the rules. This proposition being stated for a simple reason that the amendments to by amendment ordinance are made part of the substantive body of the court, not in the rules comprised of first schedule. Almost all of them relate to details of procedure to be followed by civil courts in adjudication of cases, which as numbered has traditionally been part of first schedule. A grossly egregious and anomalous situation has now been created with pits and procedure introduced by amendment against the amendments made by Lahore High Court, which now run a parallel course. There are serious contradictions between the two processes, which is most cases are irreconciled. Although, I'm reading from the last line, although in such matters considered as is not normally assigned, but in peculiar case where across the board amendments the rules have been made by committee of the High Court only a few months, Government of Punjab is obligated to have consulted LC for purpose of reconciliation. Also, while a reference to Article 2 of the Constitution has already been made, it also by implication follows that exercise of rule-making powers is constitutional, which resides in the High Court. Therefore, if such power has already been exercised, emerges as an unwritten rule to be followed in all such matters that is of utmost importance concern be held and the government of province. It is not only essential but also to preserve the independence of that is unique situation where judicial legislation is permissible. So this is the thing that once the constitutional power has been exercised by the court, because these rules made by this court have constitutional backing, this is what the judgments have said, it has constitutional backing. Even the rules under the Supreme Judicial Council, PLD 2021 Supreme Court page 1, page 94 says that though Supreme Judicial Council does not, the law does not allows them to make rules, but they made the rules, Supreme Judicial Council, and those rules have constitutional status.
So it's very look at Article 203E in relation to the Federal Sharia Court. Take a look at Clause 2. 203 capital E, Clause 2.
My Lord. Yes, my Lord. The court shall have power to conduct its proceeding and regulates its procedure in all respect as it deems fit.
This doesn't seem to be regulated by law.
No, it doesn't, sir.
So therefore, does this mean that the rule-making power of the Federal Sharia Court is on a higher pedestal as compared to the Supreme Court or the High Court?
No, my humble submission, both are constitutional powers, sir.
So
both the Supreme Court, the High Court have been granted.
I'm just coming off from what my learned colleague was asking you about the rule-making power of Federal Sharia Court. If read literally, this would mean that the Federal Sharia Court is put on a pedestal much higher than even the Court, to which appeals lie from the Federal Sharia Court.
So then there are judgments of this honourable court that if there is a conflict between a substantive provision and provision of the Federal Sharia Court, then those substantive provisions will prevail, sir. So that is also a judgment of this honourable court on this field. That constitutional provision will be higher pedestal than the provisions under the Federal Sharia Court chapter, sir.
Thank you.
My Lord. So my submission is that I was coming to that, that the jurisdiction aspect, sir. Jurisdiction aspect is that, yes, Article 175 gives the Parliament the jurisdiction to make law, but that law has to be read with Article 142A, which I read to your Lordship, sir, and Entry 55, sir.
191 confer jurisdiction or does it confer power?
I'd say it confers power, sir, because it says regulated. The most important word is that the rule make it regulate the procedure, the practice and procedure. What is the meaning of regulate?
91 is not a jurisdiction conferring article.
It is conferring power.
Conferring article. And there is a between jurisdiction and power.
And that has been very elaborately dealt with by this Honourable Court in Ziaur Rahman's case, sir. PLD 1973 Supreme Court, page 49, and the relevant question is, okay, what is the difference between judicial power and jurisdiction, sir?
PLD 73
Supreme Court, page 49, sir. And I'll give you Lordship.
Relevant page कौन सा अभी सर?
Sir, sorry, मेरी किताब जरा नहीं मिल रही, लेकिन 73 Supreme Court page 49 with a bit delay, but just
पढ़ लेंगे बाद में, अगर आपको नहीं मिला कोई बात नहीं, आगे बढ़ते हैं.
My lord, and the relevant portion, my lord, will find at page 69, sir. It starts. It refers to 68, the case of Fazl Qadir Chaudhary, sir.
First paragraph.
Para 69, sir. And it says this the whole page.
Para 69.
Page 69, my lord.
जी.
जी.
कहाँ से पढ़ें?
जी.
कौन सा पैराग्राफ?
जी, para D, जहाँ parenthesis D, paragraph से, what the Honorable Supreme Court was saying. So far, therefore, as this court is concerned, it has never claimed to be above the Constitution, nor to have the right to strike down any provision of the Constitution. It has accepted the position that it is a creature of the Constitution, that it derives its power and jurisdiction from the Constitution, and that it will even confine itself within the limits set by the Constitution, which has taken oath to protect and preserve. But it does not claim that, and has always claimed that it has the right to interpret the Constitution and to say to what a particular provision of the Constitution means or does not mean, even if that particular provision is a provision seeking to oust the jurisdiction of this court. This is the right which requires not dehose the Constitution by virtue of the fact that it is a superior court set up by the Constitution itself. It is not necessary for this purpose to invoke any divine or supernatural right, but this judicial power is inherent in the court itself. It flows from the fact that it is a constitutional court and can only be taken away by abolishing the court itself. In saying, however, I should make it clear that I am making a distinction between judicial power and jurisdiction. In a system where there is trichotomy of sovereign powers, then ex necessity derive from the very nature of things, the judicial power must be vested in the judiciary. But what is this judicial power? Judicial power has been defined in corpus juris secundum. The judiciary or judicial department is an independent and equal coordinate branch of government, and is that branch thereof which is intended to interpret, apply the law, or the department of government which is charged with the declaration of what the law is and its construction so far as it is written law. This power, it is said, is inherent in the judiciary by reason of the system of division of powers itself, under which, as Chief Justice Marshall put it, the legislature makes the executive execute and judiciary construes the law. Thus, the determination of what the existing law is in relation to something already done or happened is the function of judiciary, while the predetermination law shall be for the regulation of all future cases falling under its provision is the function of legislature. It may well be then asked at this stage as to what is meant by jurisdiction. How does it differ from judicial power? Apart from setting up the organs of the Constitution, may well provide for a great many things, such as the subjects in respect to which that power may be exercised and the manner of the exercise of that power. Thus, it may provide that the courts set up will exercise revisional or appellate powers, or only act as a court of secession, or only constitutional issues. It may demarcate the territories in which a particular court shall function, over which its writs shall run. It may specify the person in respect of whom the judicial power to hear and determine will be exercisable. These are all the matters which are commonly comprised in what is called the jurisdiction of the court. It expresses the concept of the particular rest or subject matter over which the judicial power is to be exercised and the manner of its exercise. Jurisdiction is therefore right adjudicate concerning a particular subject matter in a given case, as also the authority to exercise in a particular manner the judicial power vested in the court. In exercising this power, judiciary claims no supremacy over other organs of the government, but acts only as the administrator of the public will. Even when it declares a legislative measure unconstitutional void, it does not do so because the judicial power is superior in degree or dignity to the legislative power, but because the Constitution has vested it with the power to declare law is in the cases which come before it. It thus merely enforces the Constitution as a paramount law whenever a legislative enactment comes into conflict with it, because it is a duty to see that the Constitution prevails. It is only when the legislature fails to keep within its own constitutional limits, the judiciary steps in to enforce compliance with the Constitution. This is no doubt a delicate task, as pointed out in the case of Fazl Qadir Chaudhary vs. Shah Nawaz, which has to be performed with great circumstance. It has nevertheless to be performed as sacred constitutional duty when other state functionaries disregard the limitation imposed upon them or claim to exercise power which the people have been careful to withhold from them, sir. So this is the difference between jurisdiction and judicial power. The power exercised under 191 is a constitutional power vesting in this court to regulate the practice and procedure of the court, and Parliament cannot interfere in that because that's exclusively given. If it was have said until the parliament makes the law, the Supreme Court can make the rules of procedure, etc. These kind of words were not used. Where the Constitution specifically uses these words, then the law is being given. But it says subject to, that is implying there's not enabling provision, it's a restrictive provision. This is my humble submission.
Anything else?
Mr. Zubairi, the similar principle was reiterated in Sharaf Afridi's case.
That was regarding independence of judiciary, and that was separation of judiciary, PLD 94, Supreme Court, page 105.
Added note by Salim Akhtar.
Ji, sir. Ji. And it was coming from a larger bench of the Sindh High Court, 89 Karachi, page 404. That judgment was upheld, authored by my Lord Ajmal Miazi then was, sir. My Lord.
I think if you argue in context of Pakistan and what's happening and why presumably the legislator enacted this.
I understand, sir.
No, you're not. Now let me pose a certain queries to you. This, they are giving a right of appeal. Now we're talking about the right of appeal under 184(3).
My Lord.
Correct?
Yes, my Lord.
अब 184(3) में जो हक दिया गया है अपील का, आपने बिल्कुल ये बात नहीं करेंगे कि 184 कैसे इस्तेमाल किया गया है।
ठीक सर।
ठीक है, या तो कहिए बिल्कुल सही इस्तेमाल हो रहा है, या कहिए बिल्कुल गलत हो रहा है, या कहिए कभी सही हो रहा है कभी गलत। कुछ तो बयान कीजिए ना, क्योंकि आप तुम्हारे सामने पिटिशन नहीं लाए। मुझे समझ नहीं आ रहा है आपकी एंग्जाइटी क्या है इस लॉ से। वजाहत से बात कर दें तो हम समझ जाएंगे। अब सवाल अभी तक आया नहीं है। 184(3) जो है ना का इस्तेमाल कैसे हुआ है पाकिस्तान में, हकीकत क्या है? ह्यूमन राइट्स सेल, कोई रूल में उसका तस्करा है बताइए है, किसी कानून में तस्करा है बताइए है। अभी तो हम चलें पार्लियामान को तो छोड़ दें, हमारे अपने रूल्स में उसका तस्करा है। अब 184(3) जहां तक हेबस कॉर्पस की बात है उसका तो रूल में तस्करा है, मगर जो दूसरे इख्तियारात इस्तेमाल किए गए हैं 184(3) के तहत, उनका रूलों में तस्करा था नहीं था, कैसे इस्तेमाल किया गया। और अगर आप कहते हैं कि रूल की भी जरूरत नहीं उधर, अब तो हम रूल से भी चले गए ना। 191 ये तो नहीं देता है इजाजत के चीज बना सकता है रूल, या ह्यूमन राइट्स सेल बना सकता है, या तो कहिए है। तो वहां तो आप अपनी आंखें बंद कर रहे हैं। उसमें चले यहां तक बात मान लेते हैं कि अगर 184(3) में ह्यूमन राइट सेल बन गई होती, फिर आपकी बात में वजन होता कि भाई ठीक है 184(3) में ह्यूमन राइट सेल बन गई है तो उसके तहत कर लिया है, सही किया गलत किया तो बात की बात है। तो वो बातों को तो आप बिल्कुल नजरअंदाज करना चाहते हैं कि 184(3) में। अब देखिए, इससे पहले कि दुनिया हम उंगली उठाए, मैं अपने ऊपर उंगली रखता हूं कि 184(3) का इख्तियार जो इस्तेमाल किया गया है, और हजारों केसेस में कुछ केसेस की नौयत थी कि बिल्कुल वो जनरल पब्लिक इंटरेस्ट के आप मैटर में आप ला सकते हैं उनको, कुछ थे बिल्कुल पर्सनल हो गए थे केसेस। ठीक है, पहले आप हमें उस पर तो कोई तशरीह कर ही नहीं रहे हैं, आप बता ही नहीं रहे कि कौन से रूल्स के तहत कर रहे थे। अब आप कह रहे हैं चले खैर सुप्रीम कोर्ट ने गलत नहीं, सुप्रीम कोर्ट के एक चीफ जस्टिस ने अगर गलत किया तो पार्लियामेंट को तो ये गलती नहीं करना चाहिए। तो कम से कम वहां ज्यादा वजन नहीं होगा कि वो तो कम से कम कानून के मुताबिक एक चीज करना चाह रहे हैं। यहाँ ये 184(3) का इख्तियार कैसे इस्तेमाल हुआ, ये हकीकत है पाकिस्तान की। आप न्यू जर्सी ना जाइए, आप पाकिस्तान में रहिए और यहीं की बातें थोड़ी हम लोग कर लें। कैसे इख्तियार हुआ बता दें, ये आप बिल्कुल तरीक़ेकार से फिर बात सही है। अगर आप कहते हैं नहीं था तो फिर आप उसकी रेमेडी, अगर एक गलती होगी फिर उसकी रेमेडी तलाश करना किसकी जिम्मेदारी है? सबसे बड़ी जिम्मेदारी इस अदालत की है, इसके बाद शायद पार्लियामेंट की पड़ती है। अगर हमने गलती की हमें दुरुस्त करना चाहिए, अगर पार्लियामेंट ने गलती की है तो पार्लियामेंट को दुरुस्त करना चाहिए। अगर हम अपनी गलती नहीं दुरुस्त करते हैं तो पार्लियामेंट क्या कर सकती है? नहीं। आप बस सिर्फ उस बात पे खड़े हुए हैं, मगर जितनी वो जो पाकिस्तान में जो कुछ हुआ है उसको वो नजरअंदाज करें, चाहे वो प्राइस शुगर का तयन कर ले या कोई और बातों का कर ले। भाई वहां तो रूल्स बना लेते। एक ऑर्डर था मेरा कि भाई चलें रूल्स बना ले, फिर इसको हम कर लेते हैं। तो वहां तो आप जा ही नहीं रहे हैं। तो आपका जो कंडक्ट आ जाता है क्वेश्चन में कि आप एक पॉलिटिकल पार्टी को रिप्रेजेंट कर रहे हैं या पीटीआई को नहीं कर रहे हैं।
नो सर,
आप किसको कर रहे हैं?
ऑन नोटिस एज प्रेसिडेंट ऑफ द सुप्रीम कोर्ट।
आप सुप्रीम कोर्ट को कर रहे हैं जी। आप किसकी चले खैर ठीक है। तो सुप्रीम कोर्ट का हमें बताएं ना मौक़िफ़ क्या। अच्छा, सुप्रीम कोर्ट बार एसोसिएशन का मौक़िफ़ क्या कि 184(3) जैसे इस्तेमाल हो रहा था सही हो रहा था? तो फिर बता दीजिए ना। अगर हम इस कानून को ختم کر دیتے ہیں، کلعقدم کر دیتے ہیں، تو کل میں اس کا استعمال ویسے ہی کرتا رہا ہوں جیسے پہلے ہو رہا تھا، وہ صحیح ہوگا؟ اس کا جواب دے دیجیے گا.
بالکل میں آپ سے متفق ہوں اس بات
میں نے کوئی یہ پوائنٹ آف ویو نہیں دیا، میں آپ کا سمجھنا چاہ رہا ہوں. میرے نہ کہیے کہ میرا موقف ہے یہ.
سر آپ کا موقف تو ہم سن چکے ہیں کہ آپ
نہیں، میرا موقف نہیں ہے.
آپ نے کہا کہ جی آپ اپنے پاورز گیو اپ کرنا چاہتے ہیں، آپ نے کہا
نہیں، یہ وہ الگ بات ہے. یہ ابھی بات ہو رہی ہے 184(3) کی، پروسیجر والی بات الگ ہے، وہاں پاور کی بات.
پہلے میں پوچھا بھی تو یہاں 184 پہ تو آیا ہی نہیں تھا. میں
175 کی جو بات ہو رہی ہے 184(3)
میں تو پھر آپ سوال ہو گئے تو مجھے آنے تو دیں 184 پہ. اس پہ
آپ کب آئیں گے؟ 10:30 بج گئے
سر. آپ 11:30 تک سے پہلے میں انشاءاللہ ختم کر لوں گا. لیکن
آپ کو نہیں 11:30 کہا تھا، سب کو کہا تھا.
اچھا سر، میں آپ سے جو عرض کر رہا ہوں کہ 184(3) پہ تو بھی آیا نہیں تھا، لیکن بالکل آپ سے متفق ہوں اس بات سے کہ 184(3) کا غلط استعمال بھی ہوا ہے. اس پہ بہت چیزیں جس پہ بہت سوالات اٹھے، لیکن پوائنٹ از دیٹ بات میں جو آرگیو کر رہا ہوں سپریم کورٹ بار کہ
آپ ایک فلسفائی بات کر رہے ہیں.
نہیں سر،
حقیقت میں وہ نہیں ہے.
آپ نے پہلے مجھ سے پوچھا کہ صحیح استعمال ہوا غلط، میں اس کا جواب
نہیں تو پھر اس کا حل بھی بتا دیں.
حل آ رہا ہوں نا صاحب، پہلے وہ بات بتا رہا ہوں جو آپ نے مجھ سے سوال کیا، اس پہ حل کی طرف آ رہا ہوں. میں جو عرض کر رہا ہوں کہ سر اس کا صحیح استعمال ہوا غلط استعمال ہوا، دیکھنا آپ کو یہ ہے کہ کمپیٹنس کس کی ہے اس کو صحیح کرنے کی، جورسڈکشن کس کی ہے.
نہیں دیکھیں یہ بڑی اچھی بات ہے کہ آپ نے اب اپنی ذمہ داری ایک دم ہم پہ ڈال. نہیں میں آپ کی رائے پوچھ رہا ہوں تو آپ نے کہا دیکھنا آپ کو آپ کی کوئی رائے ہے، آپ پاکستان کی سب سے بڑی باڈی ہیں وکیلوں کی، تو بتائیے نا اپنی رائے بتائیے.
جی
عابد زبیری صاحب. جی سر، اسی ٹیکسٹ میں اگر جو پریکٹس اینڈ پروسیجر ہے ایگزسٹنگ، اس کے تحت سے 184(3) کو لے، اگر وہ فنڈامنٹل رائٹس کو وائلیٹ کرتا ہے، اٹ ہیز دی ایفیکٹ آف وائلیٹنگ دا فنڈامنٹل رائٹس، کیا پارلیمنٹ جس کے پاس ویسے اختیار ہے کہ وہ سپریم کورٹ کی جورسڈکشن کو انلارج بھی کر سکتے ہیں اور سپلیمنٹل پاورز بھی کنفر کر سکتے ہیں، کیا وہ فنڈامنٹل رائٹس کے کانٹیکسٹ میں، ایکسیس ٹو جسٹس کے کانٹیکسٹ میں، از اٹ بیریفٹ آف جورسڈکشن؟ اگر سپریم کورٹ اپنے رولز کے تحت اس کا ایفیکٹ یہ ہو کہ فنڈامنٹل رائٹس وائلیٹ ہو رہے ہیں، ایکسیس ٹو جسٹس.
بالکل صحیح سر. میں 184(3) کی بات نہیں کر رہا، آپ نے پریکٹس اینڈ پروسیجر
You had, I think, come on track.
جی.
And I had said this in the first hearing. It is not a question of good, bad,
it is no competence, sir.
It is the question of competence.
Who is there to correct it, or who has to be here to make the law?
A law may be a very good law,
yes,
but if somebody who is not competent to make it,
Ji.
it is in conflict with the constitutional powers, jidhar trichotomy of powers hain. آپ ہمیں یہ کمپٹنس پہ بتائیے کہ کس کی کمپٹنس.
وہ تو بات ہم سمجھ گئے، آپ کا موقف یہ ہے، وہ تو بات سمجھ گئے، مگر میرا سوال اس کا مطلب یہ نہیں کہ آپ اس کو نظر انداز کر لیں صرف کمپٹنس پہ. تو وہ آپ بتا دیجئے، اس پہ تو آپ ہم سننا چاہتے ہیں آپ کی رائے.
اپیل کے اوپر آ رہا ہوں، لیکن پہلے میں جج صاحب کا سوال دے دوں. اطہر من اللہ صاحب نے جو پوچھا، مائی لارڈ مائی آنسر از دیٹ اٹس ناٹ اے میٹر آف گڈ اور بیڈ اور غلطی، اٹ از اے میٹر آف کمپٹنس. My Lord has to see, this court has to see whether they had the competence to even correct that thing by making this law.
Then you have not crossed the first hurdle. There's a presumption of constitutionality.
جی.
آپ نے ایک law challenge کیا ہے.
جی.
اس کی rebuttal کے لیے آپ نے نہ standing بتایا ہے، نہ 184(3) کے تحت ابھی تک یہ بتا سکتے ہیں آپ کون سا فنڈامنٹل رائٹ انفورس کر رہے ہیں. آپ اس مینٹینیبلٹی کو بھی نہیں کراس
سر. میں
ہم ایک ایبسٹریکٹ میں وی آر
سب 191 کے پہلے دیکھیں
آپ سے میں نے سمپل ایک سوال یہ
jurisdiction of this court is not just
آپ سے سمپل میں نے ایک سوال پوچھا ہے. ایکسیس ٹو جسٹس جو ہے وہ ڈینائی ہو رہا ہو، یہ سپریم کورٹ ڈینائی کر رہی ہو،
جی
فنڈامنٹل رائٹس وائلیٹ کر رہی ہو، کین دا پارلیمنٹ ناٹ legislate?
My humble submission, no, they cannot. If the court is violating any of the rules of the Constitution, then case should be brought before the Honorable Supreme Court to challenge that thing. That is the way to challenge the law. Any rule made by the Supreme Court, Parliament cannot make.
میرے سوال کا بھی تھوڑا جواب دیں.
مجھے یہ بتائیے عابد صاحب جی، the Chief Justice exercised his powers under before law by fixing these petitions. Why not more important petitions like enforced disappearances, other human rights issues? Now, that is a question which the Parliament wanted to address. Why should these cases have been taken first? Why not other most important cases?
My humble submission is practice and procedure, only the power to regulate the practice and procedure rule-making vest in the court. It does not vest in the Parliament to make the practice and procedure, even if there was something.
ये बात आप कह चुके हैं, नई बात कर देना, सवाल जवाब देना.
And the law can be challenged on two grounds: that violates fundamental rights or is in violation of some constitutional provision. That is the jurisdiction of this honourable court, not just the violation of the fundamental right, but if the law itself is in violation of some constitutional provision, that can be struck down by this court. So that is the jurisdiction of this court.
That is under
अब आप बताएंगे मेरे सवाल. अब आप आबिद साहब, मेरे बात की
High Court has also jurisdiction 199.
तो मैं लिखूं, मैं अपना लिख देता हूं. It was put to him and he is not answering.
Sir, I'm coming, but my lords.
आप पहले वन बाय वन कर दीजिए.
अच्छा, बहुत बेहतर सर. जी. अच्छा, 184(3) पढ़ें सर पहले प्लीज.
नहीं, मैंने जो बात की वो पढ़ तो 100 दफा लिया है. मैंने जो आपको बातें बताई उसका जवाब, आपकी राय क्या है?
मेरी राय ये है कि जी अपील का हमारी स्टैंड भी का राइट होना चाहिए, बट इट हैज टू बी गिवन थ्रू अ कॉन्स्टिट्यूशनल.
ये बात नहीं की थी मैंने, कहा जितना इस्तेमाल हुआ सब सही हुआ.
मैंने जवाब दिया, आपने कहा. मैं
आपसे पूछ रहा हूँ.
मैं कहता हूँ नहीं, अगर नहीं भी हुआ है सही,
अगर पूछ रहा हूँ, आपकी कोई राय नहीं है. प्रेसिडेंट ऑफ सुप्रीम कोर्ट,
सही भी हुआ है, गलत भी हुआ है,
नहीं
भी अपील होनी चाहिए. मैं कहता हूँ
आप ये, मैं पूछ रहा हूँ आपकी राय में, इन योर पर्सनल ओपिनियन, अगर मगर ना करें, सीधी बात करें ना. आप क्या हुआ है, सारे सही हुआ.
मैं कह रहा हूँ कि दोनों अच्छा भी हुआ है, गलत भी हुआ है. जी मेरा ये, और ये मैं आपसे आपके सवाल का जवाब.
ठीक है. अच्छा, अब आप दूसरा सवाल सुन लीजिए. आपका ये कहना है कि तरीके कार गलत है, यही आपका आर्ग्यूमेंट है ना? ये राइट देना चाहिए मगर आइन को तरमीम लाने की, ये आपका बिग मौक़िफ़ है जी. अच्छा, अब सुनिए, क्योंकि जुरिस्डिक्शन ना हम बढ़ा सकते हैं और ना पार्लियामान बढ़ा सकती है. हम ये केस सुन कैसे रहे हैं फिर जी? हम 184(3) में सुन रहे हैं ना एक केस जी. हमने जुरिस्डिक्शन बढ़ा दी या क्या ये नहीं बढ़ाई? क्योंकि जुरिस्डिक्शन कर्टेल्ड है 184(3) में. दो बातें, पब्लिक इंपॉर्टेंस एंड इन्फोर्समेंट ऑफ फंडामेंटल राइट. अब कौन सी फंडामेंटल राइट इन्फोर्स कर रहे हैं? आप कह रहे हैं यहाँ बढ़ा दीजिए मगर वहां ना बढ़ाइए, तो यहाँ ये हम केस सुनने से ही अपनी जुरिस्डिक्शन बढ़ा रहे हैं.
नहीं सर, आपने,
ये आपका मौक़िफ़ होगा.
आपकी 184(3) के अंदर फंडामेंटल राइट्स की वायलेशन भी सुप्रीम कोर्ट मैटर ऑफ पब्लिक इंपॉर्टेंस, और अगर कोई कानून मुकन्ना बनाती है तो उसके ऊपर डिक्लेयर करना कि वो कानून आइन के मुतसादिम है, वो भी आपका हक है अंडर 184(3).
अच्छा, जब इनकम टैक्स ऑर्डिनेंस में, फैमिली लॉज ऑर्डिनेंस में जब भी कोई अमेंडमेंट आ जाए तो सीधा सुप्रीम कोर्ट में 184(3) के तहत हो सकता है. आपका कहना ये
बिल्कुल हो सकता है. इफ माय लॉर्ड,
ठीक है, ये मैंने नोट कर लिया.
बिल्कुल करें सर.
इवन इफ इट्स नो फंडामेंटल राइट इज इन्वॉल्व.
नहीं, फंडामेंटल राइट्स हो सकता है, लेकिन
टैक्सेशन मैटर में फंडामेंटल राइट होती है.
कोई अमेंडमेंट भी चैलेंज हो सकती है, वहां भी हो सकता है, लेकिन पब्लिक इंपॉर्टेंस का इशू आता है सर. व्हाट इज द मैटर? देखिए, दो कंडीशंस होती है ना सर, पब्लिक इंपॉर्टेंस एंड फंडामेंटल राइट्स.
इट्स नॉट आइदर और, इट इज बोथ साइमल्टेनियसली.
वही मैं कह रहा हूं कि आप दोनों चीजों को देखना होगा, सिर्फ फंडामेंटल राइट्स को नहीं देखना होगा आपको.
तो ये केस में क्या फंडामेंटल राइट है बताइए ना हमें.
इसमें फंडामेंटल to justice का my lord was saying कि
कौन सा आर्टिकल बता दें, वो वाला आर्टिकल सर. आर्टिकल राइट टू लाइफ.
राइट टू लाइफ में होल्ड किया गया है कि
जी, होल्ड नहीं किया गया, उसके लफ्ज में बता दें कौन से में आता है, तो मैं लिख लूं
जी. एक्सेस टू जस्टिस एंड इंडिपेंडेंस ऑफ जुडिशरी इज बीन हेल्ड टू बी इनकॉर्पोरेटेड इन द वर्ड्स ऑफ आर्टिकल 9 से. तो आप लिटरल रीडिंग में तो नहीं है, इंटरप्रिटेशन
लिटरल में नहीं है ना, तो ये तस्लीम आप करते हैं. लिटरल में नहीं है, इंप्लाइड रीडिंग में है.
नहीं, जजमेंट्स ऑफ द ऑनरेबल व्हिच इज बाइंडिंग is says के जी access to justice since high court
binding, it may be binding on you, not on us.
Sir, since high court bar का जो फैसला है 2009 सुप्रीम कोर्ट 879, which is a full court फैसला, उसके अंदर लिखा हुआ है कि जी आर्टिकल 9 की वायलेशन में access to justice इंडिपेंडेंस.
चलिए ठीक है, मेरा सवाल का जवाब मिल गया मुझे. आप आगे बढ़िए, आप आगे बढ़े. हाँ,
मेरे साहब ये बता दें कि आप कह रहे हैं एक्सेस टू जस्टिस की बात है, सिटीजन एट लार्ज की बात है. इस एक्ट के तहत वो कौन सी कोई ऐसी प्रोविजन में है जो पब्लिक को डिबार करती है टू अप्रोच द सुप्रीम कोर्ट? ऐसे कोई प्रोविजन जो कह सके कि
इसमें जो बात है इंडिपेंडेंस ऑफ जुडिशरी, वी हैव अ वेस्टेड इंटरेस्ट इन द इंडिपेंडेंस ऑफ जुडिशरी. दिस लॉ, इसमें अच्छा लॉ होगा, बहुत अच्छा लॉ होगा, लेकिन इशू ये है कि इट इज द कॉम्पिटेंस. अगर कॉम्पिटेंस नहीं थी देन इट्स नॉट अ राइट लॉ, इट इज अल्ट्रा वायरस.
मेंटेनेबिलिटी की बात कर रहा हूँ. इस एक्ट को देखने के लिए हमने ये देखना है कि आया इसकी या टोटल एक्ट किसी भी फंडामेंटल राइट के अगेंस्ट है, या इसके जरिए कोई पब्लिक या किसी सिटीजन का हक मारा जा रहा है कि उसे पहले तो अपील की हक थी अब नहीं दिया जा रहा है, पहले ट्रायल की हक थी अब नहीं दिया जा रहा है, ऐसी कोई प्रोविजन इसमें है कि हम कह सके कि ये इलीगल?
सर मैं कह रहा हूँ इसकी प्रोविजन आपको ये देखनी है कि क्या ये कानून साजी हो सकती है।
जवाब दें उसके बाद पहले।
मैं आ रहा हूँ सर, मैं आपको जवाब ही दे रहा हूँ। मैं कह रहा हूँ कि इसमें ये देखना होगा कि क्या कानून साजी का इख्तियार था के पास टू मेक दिस लॉ।
चलिए इसमें बता दो, आपने पहले कहा कि 1980 में रूल्स बने
जी,
वो रूल एग्जिस्टिंग लॉ के तहत बने
जी,
ये तो आप मानते हैं कि रूल लॉ के तहत बनने चाहिए
जी,
तो क्या आप बता सकते
रूल बने 191 के तहत सर,
191
आर्टिकल रूल लॉ के तहत।
आपने थोड़ी देर पहले जो आर्गुमेंट से आपने कहा कि एग्जिस्टिंग लॉज के मुताबिक 1980 में रूल
जी बिल्कुल एग्जिस्टिंग लॉ।
प्लीज मुझे ये बता दें, मेरी नजर से तो नहीं गुजरे, 1980 में उस वक्त कोई ऐसा कानून था जो सुप्रीम कोर्ट की प्रैक्टिस को
नहीं
फॉलो कर रहा था?
बिल्कुल नहीं
तो
था।
ये रूल कैसे बने
अंडर 191? 56 के बने, पहले बने 1956 में।
लॉ कहाँ गया
सर? लॉ अगर कोई लॉ है, वर्ड यूजेस सब्जेक्ट टू लॉ। सब्जेक्ट टू लॉ मींस कि कोई लॉ अगर होता, कोई भी लॉ हो, इट कैन बी एनी लॉ, सब्सटेंटिव लॉ।
आई थिंक कि वो 191 वाला आर्ग्यू आप कर चुके थे, अब आप 175 पे थे।
लॉ कोई था जिसके वायलेशन में नहीं बन सकते थे, ये मेरे हम्बल सबमिशन थी।
ठीक ठीक ठीक,
ये लॉ प्रोसीजर।
अगला पॉइंट बताएं
अगर कोई होता।
If I may ask you a question. The equivalent to Article 184(3) of our Constitution, I think, is Article 32 of the Indian Constitution.
जी my lord.
Which guarantees the right to move the Supreme Court for violation of fundamental rights. If memory serves me right, Mr. Ambedkar, who is regarded as the father of the Indian Constitution, in relation to this jurisdiction conferred on the Supreme Court, said it is the very soul of the Constitution.
जी.
Now, if that is correct, and in India no one has ever doubted that that is correct, we are here talking of the very soul of the Constitution.
Yes. And
it seems to me that, and this is my question to you, that can a challenge to a law which, according to you, whether right or wrong, that's yet to be decided, that is an assault on the independence of the judiciary, is that not an assault on the very soul of the Constitution?
Of course, because
can it be therefore put to one side simply by saying that it is not in violation of fundamental rights?
No, because my humble submission is that, this is what my humble submission is, that the very purpose this law, and I read that judgments, that it affects the separation of doctrine of separation of powers. My lord, this court has the exclusive jurisdiction.
ये point आप repeat करते रह रहे हैं। अगला point
that's why if any law which is made in violation of that cannot be, that affects the fundamental rights of the people of Pakistan and access to justice.
Next point.
184 की जो power, that's the original power of this court. There's appellate power is 185, sir. Advisory power is 186. Review power is 188. These are the four powers which are given by the Constitution.
No, you are wrong. There are other powers also.
I'm talking about these are the appellate when की बात कर रहा हूँ, चार powers की जो दी हुई है. Now, the original framing में appeal का right नहीं था. Appeal is only provided under Article 185. Now, if you want to give an appeal, my humble submission is that you have to amend the Constitution. And why? Because section आप पढ़ेंगे sir, Article 175, 142 देखा. अब entry 55 देख लें sir. What does entry 55?
पढ़े.
जी. My lord, 175(2), Article 142A and entry 55 have to be read together, not in.
पढ़ने 55 से कहाँ से शुरू करना चाहते हैं?
Jurisdiction powers all courts except the Supreme Court with respect to any of the matters list and to such. Now I'm coming to emphasize this last part, sir. The second part of this entry, and to such extent as expressly authorized by or under the Constitution. Now these are very important words, and my lord, I'll keep that my lord's thing. And by or under the Constitution, the enlargement of the jurisdiction Supreme Court and conferring thereon of supplemental powers, sir. The point is that the thing, पिछले जो आपके जो लिस्ट थी, उसके अंदर ये words नहीं थे. In the 56 Constitution, 62 and 72, expressly authorized by.
पढ़ लिए, अब आप argument develop करें.
Argument is that when you read all these provisions together, no court shall have jurisdiction except provided by Constitution or law. The 142, Parliament can make laws as regard for यहाँ इंक्रीज की जो बात हो रही है उस पे मैं सिर्फ एक पैराग्राफ जजमेंट,
इसके पावर इंक्रीज हो रहे हैं
ऑन द सुप्रीम कोर्ट की पावर, यहाँ आप
इसमें आप कह रहे हैं ये इंडिपेंडेंस जुडिशरी खत्म हो रही है क्योंकि पावर इंक्रीज हो रहे हैं।
सर इट इज द मेथड, द मेथडोलॉजी,
फिर वो मेथड वाला आर्गुमेंट खत्म हो गया।
नहीं सर, इसमें यही है कि
आप
आपकी ओरिजिनल जुरिस्डिक्शन के अंदर अपील नहीं प्रोवाइडेड थी उन द ओरिजिनल फ्रेमर्स ऑफ द कॉन्स्टिट्यूशन, दे डिड नॉट प्रोवाइड, ओनली द अपील वाज।
मगर मैं फिर उसका काउंटर आर्गुमेंट ये भी दे सकता हूं कि 184(3) का इस्तेमाल जिस तरीके से किया गया, नहीं देखिए आप, सॉरी टू से, इफ समबडी albeit person not even fully authorized is doing something to help the nation, help the Supreme Court, you should say strike down because they're not following some perceived letter of the Constitution. That will be a stretch. If this power had been given to the Federal Shariat Court, if it had been given to some secretary in the government or to the parliament even, then you could say yes, we ek appeal de di, in a fit of rage a judge says so and so political party I hereby ban it, khatam, koi solution nahi hai iska except review, right? You know, in a fit of rage या आपकी बात किसी को पसंद नहीं आई या कुछ मिसगी हो गई, हो जाते हैं, इंसान दोनों तरफ होते हैं, तो हम यहाँ बन करके वो फरिश्ते नहीं बनते, हम इंसान ही रहते हैं। फिट ऑफ रेज में उन्होंने कर दिया ये, तो कोई इसका सोल्यूशन नहीं है।
मैं कहता हूँ आप बिल्कुल होनी चाहिए राइट ऑफ अपील, बिल्कुल होनी चाहिए, इट्स ओनली द मेथड, बिल्कुल होनी चाहिए
मेथड। आप मेथड विल नॉट,
आपको हमें तो हम कॉन्स्टिट्यूशन पे चल,
इट्स लाइक अ पेशेंट डाइंग ऑन द, इट्स लाइक अ पेशेंट डाइंग ऑन, सुन लीजिए, पेशेंट डाइंग समवेयर, अ पर्सन रिसीव्ड अ गन शॉट वुंड, इज लाइंग समवेयर ऑन द स्ट्रीट, ठीक है। Now, someone is not a doctor, but knows a little bit of medicine. He does something, tries to press him thing. Ideally, it should be performed by the doctor. So he said, no, don't do it. Wait for the water to come. Wait for him to die. And he, of course, he's not a doctor. He may be a quack, or he may just have seen some television shows, and he may just be applying some first aid, medical trade, who's not a doctor at all, not even a nurse, to save the person. So, इसमें ये बात हमें बिल्कुल इसको कर दें इसका। आप फिर शुरू में तो आप लोगों ने अटैक कर दिया था इंटेंट ऑफ पार्लियामेंट पे, तो मैं तो कह रहा हूँ इंटेंट ऑफ पार्लियामेंट इज गुड।
तो मैंने इंटेंट ऑफ पार्लियामेंट को नहीं किया,
इस साइड से लोगों ने किया है, उन्होंने कहा कि पर्सन स्पेसिफिक लॉ है, हमें बता दें पर्सन स्पेसिफिक कैसे है।
नॉट बी डिबेटेड हियर, आई नेवर सेड दैट, आई सेड कि दिस लॉ मे बी वन ऑफ द गुड लॉज, but the point is that the way it has been done is unconstitutional. That is my case before your lordship, my humble submission. और देखिए आप बिल्कुल सही कह रहे हैं कि जी,
the question is where the Constitution has put up a scheme of separation of powers as to who can do what. There is a reason, there is a rationale, and there is a philosophy behind it which has been developed over centuries of jurisprudence. If we open the door, and this is a question of opening the door, we open the door for the Parliament to interfere in every matter that the Supreme Court may or may not take up, then there is no end to it. There would be good legislation and there would be bad legislation. How do you differentiate? The differentiation is put in the Constitution by the framers. This is what you can do and this is what you cannot do.
Yes.
Whether you want to do something good, if the Constitution prohibits you to do it, and the Constitution does not totally prohibit you. It says if there is something which should be in the Constitution is not immune from being amended to do that good.
Yes.
But to confer this power on the Parliament and say whatever you do, even if it is beyond the Constitution, if it is good, it's good. That is not how constitutions work.
Yes.
इसमें एक सेकंड है, ये ना, ये जो रैशनल जो है, हमारे रैशनल और रीजन और फिलॉसफी जो होती है, we tend to forget when there's trampling of boots. Then all these things, nice philosophies, go out the window. The only difference between a constitutional amendment and a law, the only difference is a numbers game. Do you have 2/3 majority? It's the very same persons doing the lawmaking, the same parliamentarians who are making law. It's no difference, it's just a question of numbers. Suppose a political party comes to power, on the pledge they're going to provide 184(3). They win the election. They don't have the numbers for 2/3 majority. So they are helpless. Even though it was a pledge to the nation, we'll go, the first thing we're going to do is do this. So at the end of the day, it's a numbers game. But if it's a numbers game, then we should also realize the traumatic history of Pakistan. Irrespective of numbers, irrespective of the entire nation, one person comes and then parliament is held at whatever it is held at, and 269, 270, 270 AA, and everything is done is all right. It's a post-rubber stamp, done illegally, endorsed by Parliament by amendment to the Constitution. That's all right. We forgo the history of... Hey, America mein ye cheezein nahi hoti. When we are so particular about the full stops and the commas, then we should also say it has not yet happened in America. It may happen tomorrow. It has not yet happened in the UK other than Cromwell. So we should not forget. We should keep in mind the history of the nation also, which is a very fragile history. It's half a country today because of these acts. So let's not cripple the parliament completely when they are doing good because they don't have the numbers, 2/3 majority. That's all the argument is left with. 2/3 से कर लें, ठीक है? आपका एक वोट कम है, आप नहीं कर सकते हो. That's what it boils down to that.
Sir, my lord, to defend, protect, and preserve the constitution. If the
for the people of Pakistan,
if that is the thing that
फिर हम आपसे वही सवाल पूछेंगे कितने लोगों ने किया है इसको.
Then constitution gives a mechanism, a procedure. You can, my lord, with utmost respect, it is not a numbers game. It is a constitution put. The premise said that if a constitutional amendment has to be made for the people of Pakistan, because they are representing where the independent judiciary will be fully secured, then you have that number games. It is the constitutional requirement.
Sir, you were not agitated enough either to vote in to have filed your own petition. You have filed your own petition.
No,
or you're on notice.
Notice, sir.
So you were not agitated enough to have filed your own petition. Some people came and filed their own petition. So if you were so agitated, you should have done it the very first day yourself. Supreme Court, it would have been very nice to see Supreme Court Bar Association.
जो cases file के वो तो take up नहीं हो रहे जो Supreme Court
वो क्यों नहीं हो रहे take up? क्योंकि आप ये केस को खत्म ही नहीं करना चाहते.
बात नहीं है सर.
खत्म करें.
The Constitution says we, the
people
of Pakistan,
excuse me, जरा हमें भी question करने का time दिया जाए.
Give ourselves the following Constitution.
जी.
Now, the people of Pakistan have said, if we want to amend the Constitution,
जी.
we would do it through our
representatives. ये argument हो गया, आगे बढ़ते हैं. चलिए ठीक है, समझ रहे हैं 3/4 का आर्गुमेंट. चलें आगे बढ़ें.
मिस्टर जुबैरी,
क्या मैं सवाल कर सकती हूँ? Excuse me.
जी पूछिए जैसे.
My lord.
जी, the act says that subject to constitution and law, they have amended, they either taken the power of the Supreme Court by making rules. So what article of the constitution they have referred to? They have referred to.
They have referred.
Amendment has been made. We are opening the doors.
जी बिल्कुल सही.
In future for amending the constitution.
My humble submission is Article 175.
Simple majority.
175(2) has been read in isolation to amend this law. Basically, an amendment has been done in the Constitution by amended by 175(2). And my humble submission is 175(2) cannot be read in isolation. It has to be read with Article 142A and Anti-55.
अगला point बताइए.
Mr. Zubairi, if I may, Mr. Zubairi,
my lord.
Mr. Zubairi, may I ask you and follow up on what my learned colleague has said, that when Constitution is being amended, it is constituent power that is being exercised.
My lord.
It is a unique power, quite separate and different from the other legislative competence that is available to Parliament. So I think what my learned colleague is saying is, if we open this door of an indirect amendment to the Constitution, we are allowing constituent power. It is not a numbers game, if I may say so, with all due respect. It is a numbers game because it is constituent power. We are allowing constituent power to flow into a channel which the Constitution prohibits directly or indirectly. So therefore, I think the point that my learned colleague has made, that this is at most, or at worst perhaps, an indirect amendment of the Constitution, which is perhaps barred by the Constitution itself.
Sir, tomorrow if this law...
नहीं, tomorrow नहीं, अभी हम यही देखते हैं.
If this law is upheld,
ये बिल्कुल
for
हम नहीं
example,
करेंगे.
then the Parliament can also decide that the last junior most judges will...
No. You cannot, we have a particular case, argue that. What happens tomorrow, I am not one who gives judgments on the basis of समाइजेस. इस पे कर लें, आप बहस खत्म कर लिया, आप वही पॉइंट्स बार बार दोहरा रहे हैं. जरा जल्दी खत्म कर लेना, आपका वक्त निकल जाएगा दूसरों का.
You are representing the Supreme Court Bar Association. You are not petitioner nor respondent. क्या आप ये बेहतर नहीं था कि आप आके कहते हैं कि जनाब इस एक्ट को पेश करने की जरूरत क्यों महसूस हुई? मेरे ख्याल में जरूरत इसलिए महसूस हुई कि हमने 184(3) के पावर्स कॉन्स्टिट्यूशन से हटकर इस्तेमाल किए, क्योंकि अगर आप इसकी वर्डिंग पढ़ें उसमें सिंपल बात यह है, फिर से अगर आप पढ़ लें, मैं पढ़ता हूं आपके लिए. विदाउट प्रेजुडिस टू द प्रोविजन ऑफ आर्टिकल 199, द सुप्रीम कोर्ट शैल, if it considers that a question of public importance with reference to the enforcement of any fundamental right conferred by chapter 1 of part 2 is involved. हमने जो ऑर्डर्स किए, हम तो लोगों को सजा भी देते हैं, हम लोगों को बरी भी करते हैं, चीनी की कीमत भी मालूम करते हैं, बहुत सी चीजें करते हैं. क्या ये अगर हम अपने इस डोमेन में रहें तो किसी लॉ या रूल की जरूरत पड़ेगी? मेरे ख्याल में नहीं.
सर आप सही कह रहे हैं, लेकिन मेरा ये नहीं है, ये मैं कह रहा हूँ कि जी ये आप पावर बिल्कुल आप सही कह रहे हैं, गलतियां की होंगी, लेकिन पार्लियामेंट उसे सही नहीं कर सकती इस लॉ के थ्रू. दैट इज माय केस. अगर आप करेंगे तो आप खुद करेंगे सर, ये अपने रूल्स में अमेंड करके. सर
इसका मतलब कॉन्स्टिट्यूशन से बढ़कर पावर
नहीं, आप अपने रेगुलेट करेंगे अपने रूल्स और प्रोसीजर को. गलती अगर आप कहें तो आप उसको करेक्ट करें, आप उसमें रूल्स अपने रूल्स अमेंड करें, उसमें आप.
अच्छा चलिए, आप इस बार यू आर रिपीटिंग योरसेल्फ. अगर हम किसी और को मौका देते हैं, यू जस्ट रिपीट. नहीं, यू वांट टू कैन, इफ यू रिपीटिंग योरसेल्फ वी विल आस्क हियर समवन एल्स.
184(3) is original jurisdiction conferred by the Constitution.
जी.
And it is the original jurisdiction, and if appeal is given, that would continuation of the proceeding before the original court.
Yeah.
This is settled.
You will have a super Supreme Court. जी.
Any provision of the Constitution where appeal is given by simple legislative power by the Parliament, that is permissible under the law.
No, my lord, under the Constitution it is not, sir. That's my. And may I just quickly take your lordship?
How would you explain enlargement of jurisdiction?
Yes, I'm coming to that.
And conferring supplementary
yes, my lord.
powers.
जी.
Because you see, to be interpreted liberally as already laid down by this court.
Number of cases, sir. My lord, humble से एक बस एक आप करके फिर खत्म करूँगा.
डायरेक्टली उस पे आ जाए ना.
जी.
If the parliament
मैं कह रहा हूँ कि जी
Parliament enlarge the jurisdiction and also to confer any supplemental power.
Yes, my humble submission is appeal जो पार्लियामेंट ने दे दी इसके अंदर, तो कल किसी चीज को भी अमेंड करके सुप्रीम कोर्ट को दे सकते हैं.
आप देखें ना, पहले इसको तो जरा
रूल 50
अगर तो जुरिस्डिक्शन एक्सपेंड कर सकती है पार्लियामेंट, तो फिर उनका इख्तियार है.
नहीं सर, with utmost respect, sir.
How do you read?
जी, I'm reading. I'll take help from a judgment of this court, 2000 SCMR, page 567, and the relevant portion is at page 617, sir. And let's read this paragraph to answer your lordships and my lords. 2000 SCMR, page 567, Province of Punjab is the National Industrial Cooperative Credit Corporation. इसमें through provincial law, appeal was provided to the Supreme Court. That was struck down. Though a judge or cooperative judge was a judge of the Honorable Supreme Court, that was said that is fine. But when the appeal was granted, it was struck down, and this is what the Honorable Supreme Court had. My lord, kindly see page 617, para 17.
Page
617, my lord. Starts at 567 and page 617. And the appeal के बाद
आ गया है फिर वही टाइम जब हर जगह सिर्फ यही शोर होगा.
Coming now to the present Constitution of 1973, it may be of the para 17, sir. It may be observed that according to the Learned Council for the Government of Punjab, in view of Article 175(2) of the Constitution, under which jurisdiction can be conferred on any court, including the Supreme Court, by or under any law, in relation to matters in respect of which provincial legislatures have power to make laws, including cooperative societies, additional supplemental jurisdiction or powers can be conferred on the Supreme Court by provincial The law mentioned in Article 170 includes a provincial law and additional supplementary jurisdiction on powers and form an appeal to the Supreme Court under Section 22 of the imperial laws being conferred on the Supreme Court in respect of a matter which the provincial have exclusive jurisdiction under the Constitution to enact laws. Now, since judgment is quoted and the finding of the court at the bottom of the page. In view, there is no ambiguity interpreting entry 55 of Part 1 of Federal Legislative List 4 Schedule 73 Constitution. Entry read with Articles 175(2) and 142A of the confers exclusive powers on the Parliament make laws for enlargement of the jurisdiction of the Supreme Court or conferring on it supplementary powers. If entry 50 was not there in the Federal Legislatures, it could be argued that under Article 175(2) of the Constitution in respect of matters relating to corporate societies exclusively falling under the comprehension of provision, a law can validly be made by a provincial enlarging jurisdiction of Supreme and conferring on its supplementary power. But Article 175 is not to be interpreted in isolation. It has to be read and interpreted along with Article 142A and entries in the legislative list. Under entry 55 of the Federal Legislature is competent to make laws regarding jurisdiction.
Actually, you are not reading the relevant part. The relevant part are 2 lines. The last is 616. Pe last line pad lijiye, and the 2 lines following that. That's what is the answer to the question. 616 की last line पढ़िए page पे.
जी, from the aforesaid. From the aforesaid entry, it follows that under the interim constitution, additional supplementary jurisdiction could only be conferred upon by a law made by. Yes, sir, interim constitution.
आप पढ़ तो लेना provision तो वही है ना. By a law by the federal legislature. वहाँ issue सिर्फ इतनी सी थी. जरा समझने की कोशिश करें ना. आप जरा सुन तो लीजिए ना हजूर. वहाँ सिर्फ ये बात उन्होंने कही. जी सूबाई उसको पावर नहीं है और स्पेसिफिकली ये जुमला इस्तेमाल कर दिया फेडरल लेजिस्लेचर कर दे तो वो प्रोविंशियल बात तो हम भी मानते हैं. मतलब मैं कम से कम मैं तो बिल्कुल आपसे एग्री करता हूँ इस बात पे.
उसकी एंटी 55 में एनलार्जमेंट की बात नहीं की हुई थी. 72 जी, इसको पढ़ लूं सर प्लीज.
एक मिनट, मैं आपसे इसके 4 लाइनें पढ़ लीजिए, उससे पूरा जवाब आ गया. 618 पेज पे आइए.
आ रहा हूँ उसी
फर्स्ट पैराग्राफ जी, लास्ट 4 लाइंस हाउएवर से पढ़ दीजिए
सर. मैं इसके ऊपर भी बड़ा इंपॉर्टेंट
पढ़ दीजिए. वो
इसका आ रहा हूँ जो माय लॉर्ड्स क्वेश्चन वाज.
अच्छा फिर आप छोड़ दीजिए. फिर अगर आप समझते हैं आप शाम तक चलाएंगे इसके
बस मैं ये आपको दे रहा हूं सर. 2 लाइनें
तो हाउएवर से पढ़ दीजिए ना.
लंबे पैराग्राफ पढ़ेंगे.
दैट इज द क्रक्स. हाउएवर से पढ़ दीजिए.
However, jurisdiction of Supreme Court can be enlarged. Supplementary powers can be conferred on Supreme Court by law in view of Article 175(2) of the Constitution. Entry 55 read with Article 142 leave no that the enlargement jurisdiction conference supplementary powers can only be done through law made by federal.
लेकिन ये है सर, लेकिन इसका ऊपर वाला रेशियो ऑफ द जजमेंट.
ये रेशियो है.
बस रेशियो ऊपर भी है सर.
अच्छा अब हम आपको खत्म कर रहे हैं
सर. खत्म हो गया सर. 1 मिनट.
आपने पढ़ा है. दिस इज द मेयर रीस्टेटमेंट ऑफ व्हाट इज रिटन.
हम पढ़ लेंगे ना. यार देखिए ये हमारा काम नहीं. आप हमने बता दिया, हमने नोट कर लिया.
असल उसका क्रंच वो.
अच्छा अगर आप सॉरी टू से अब हमें एक ही इंप्रेशन मेरे जहन में क्रिएट हो रहा है कि आप चाहते हैं कि 184(3) के केसेस जो लगे हुए लगे नहीं कोर्ट में, क्योंकि आप चाहते हैं कि खत्म ही ना हो कभी. तो बस आप खत्म कर दीजिए ना. आपने बता दिया, हम पढ़ लेंगे. शुक्रिया.
मैं कह रहा हूँ आइसोलेशन में नहीं पढ़ा.
अच्छा अब आप कोई और पॉइंट है तो हम सुन के आपको दोबारा नहीं सुन रहे हैं.
दूसरा पॉइंट जो है कि जी इसके अंदर रिट्रोस्पेक्टिव इफेक्ट दे दिया 18 सेक्शन 5 के अंदर कि जितने केसेस हैं वो सब खुल सकते हैं.
पहले जरा क्लैरिफाई कर दीजिएगा जी. ये जो रिट्रोस्पेक्टिव इफेक्ट है ये सिर्फ 184(3) के लिए है जी. अगर किसी ने 188 के तहत रिव्यू एक्सरसाइज कर ली है उसके लिए नहीं है. देयर इज नो अपील अगेंस्ट रिव्यू, सो देयर वुड बी हार्डली एनी केस लेफ्ट फॉर दिस अपील टू बी एक्सरसाइज.
ठीक है सर, आप सही कह रहे हैं. लेकिन पॉइंट इज दैट giving of power, who can give that power appeal?
आप बता देना उसका इफेक्ट क्या है.
इसका इफेक्ट ये है कि
hardly any effect.
सर मुझे नहीं मालूम
कि it is not a power against a review.
I am not there to say कि कितने केसों में रिव्यू हुआ है. नहीं, बास केसों में नहीं हुआ होगा रिव्यू. उसके ऊपर तो राइट खुल जाएगा फ्रॉम 1973.
आपको घबराहट क्यों है? हमारे काम बढ़ जाएगा ना.
घबराहट की बात नहीं है.
मैं समझना चाह रहा हूँ सिर्फ
ये केस घबराहट से आर्गुमेंट नहीं है. आप कॉन्स्टिट्यूशन या तो प्रिवेल या नहीं करेगा. अब वी हैव नो टू वेज. आइदर द कॉन्स्टिट्यूशन के
ठीक है बार-बार ये बात रिट्रेट ना करें.
नहीं, समझ गए. घबराहट तो नहीं हो रही सर. घबराहट तो नहीं हो. पॉइंट इज दैट कि आइदर कॉन्स्टिट्यूशन इजाजत देता है या नहीं देता. ये कॉम्पिटेंस है या नहीं.
सुन ली बात ना. बार-बार कहने से कोई फर्क तो नहीं पड़ता है ना. खत्म. अब आप अगले जो होंगे सुनेंगे उनको. अगर उनको आपको 20 मिनट सुनेंगे. ठीक है
Thank you, sir. विश्व की तरफ से एक दो हैं, ठीक है? हाँ, इस पे ठीक है. वही अपील भी कर दे, करिए. Power of Supreme Court will become functus officio. Constitutional grant of rule-making power is construed as a continuing power, sir. So there cannot be any limitations on that, or constitutional power given that. It is not an enabling provision. Subject cannot mean legislation, sir. As subject law is interpreted as Supreme Court's rule-making power are subject to then, that would be a grave violation of independence and separation of powers doctrine, sir. Subject law means substantive law. Subject to law means substantive law as distinguished from pleading and practice. Substantive law includes much more than legislation. It includes common law. Subject to law means power as to practice must not invade the field of substantive law. So there has to be something existing. It cannot invade the field of substantive law. But it does not give them the power to legislate.
As already laid down by this court.
Number of your Lordship's kind permission, I have prepared
What you're saying is that the Parliament cannot make rules nor legislate regarding the rules. And all the Parliament can do is subsequent legislation नहीं हो सकती. ये जो existing law था उसके दायरे कार में रहते हुए और कानून
आप rules नहीं बना सकते.
Constitution के दायरे कार में रहते हुए power in any event vests in the Supreme Court.
Supreme Court exclusively, sir, because the word used is not just rule making; it is regulate. That we can by rule regulate the practice.
I'll read the provision.
Yes, my lord.
Let's reframe the whole provision.
My lord.
It says, now let's read it like this.
My lord.
The Supreme Court may make rules regulating the practice and procedure of the court.
Yes, my lord.
So are you saying that Supreme Court had to be advised about the Constitution, had to be advised about the law, because it would make rules which will be completely in violation of the Constitution and the law? So it would have been much simpler drafting to start it with the Supreme Court. Rules regulating practice and procedure of the court. Your contention is that a high body, as the constitutional body, as the Supreme Court, had to be reminded that there is a constitution in existence. Don't violate it. That's a very strange proposition.
No.
You are putting redundancy to the words subject to the constitution and law, because what you are saying can equally be said by using these words.
My lord, with the utmost respect, my lord.
If you read it
जवाब दे नहीं, let's hear the counsel. जी प्लीज सुन लेते हैं counsel को.
I'm also reading it the same way. The Supreme Court may make rules and regulating the practice and procedure of the court,
my lord,
subject to the Constitution and the law.
My lord,
which means Supreme Court can make rules,
yes,
whatever rule it wants to make.
जी.
But it can't go beyond
the Constitution or any law which already exists.
So there is
वो मेरा सवाल अपनी जगह ठहरा. हजूर आप जवाब तो दे दीजिए.
My lord, with utmost respect, I'm not reading it as
utmost respect को छोड़िए, सिर्फ जवाब दे दीजिए.
अच्छा सर, आपके साथ
मेरा वक्त की कमी है.
जी, I know, my lord. I'm just saying that subject to law, subject means some kind of restriction.
मैं आपसे कुछ और मैंने आपसे फिर से आप देखें जो मैंने सवाल है उसका तो आप जवाब
मैं आ तो जाऊँ
नहीं. आप आएंगे तो अगर दिन निकल जाए. मैंने कहा अगर ये हम लफ्ज काट दें सब्जेक्ट टू द कॉन्स्टिट्यूशन एंड द लॉ, फर्क क्या पड़ेगा फिर?
जी,
ये इसका सवाल का जवाब दे दीजिए.
फर्क नहीं पड़ेगा, लेकिन पॉइंट इज दैट
नहीं पड़ेगा ना.
नहीं, लेकिन
थैंक यू.
इशू
चलिए नेक्स्ट पॉइंट.
नहीं सर, पहले अभी सुन तो ले, मैं कंप्लीट तो कर लूं सर आपकी इजाजत से. अगर फिर भी कोई लॉ आप रूल नहीं बना सकेंगे which violates any provision of the Constitution.
Is this something to be taught to the Supreme Court?
No sir, but I'm humbly submitting subject to law does not mean the Parliament can legislate. Humble submission. Subject to, क्योंकि जहाँ Parliament, जहाँ Constitution power देता है Parliament को बना दे, specific words are used.
चलें खैर,
जी.
अब पता नहीं आप redundancy is
I'm not assuming it is. I'm
1,
just
2,
saying.
3, 4, 5, 6 words of the Constitution we can delete as rendered meaningless.
So I'm
reading it like that. Noted. Next point.
The point is that the words used in the if Parliament, if Constitution is giving power to the to make any law, it specifically used certain words in the Constitution. If my Lord kindly sees 154(5), Article 154(5). Next page. My Lord, until Majlis Shura Parliament makes provision by law in this behalf, the Council may make its rules of procedure. These are the words. Then Article 6.3, my Lord, if my Lord kindly sees Article 6.3. Article
6.3 or 63?
6.3. Article 6, subclause 3. I see him again. 6, Article 6. Majlis shall by law. Article 6, my Lord. Yeah.
जी पढ़ लिया
जी Majlis shall by law provide punishment of persons found guilty of high treason. Then my Lord will kindly see 151(2), freedom of trade. And my Lord also reads 150, subject to clause 2, trade, commerce, intercourse throughout Pakistan shall be. Majlis Shura may by law impose such restrictions. May by law. Again, sir. Then my Lord,
what is the point you're making?
I'm making.
You're just citing the provisions.
My Lord, if the word in the 191 was the Parliament can make law, these kind of expressions as provided in the Constitution would have been used, my Lord. My humble submission is that when the Constitution is giving the legislature a power to enact a law, then specifically words are used in the power.
Mr. Zubairi, there's another question.
My Lord.
Once the rule-making power has been exercised,
my Lord,
by the Supreme Court, in terms of the Constitution, because the power vests in the Supreme Court, can subsequent legislation displace, as this Act purports to do so, can subsequent legislation displace the rules that have lawfully been and constitutionally been framed by the Supreme Court?
That's my humble submission. They cannot, for the simple reason, because then it will become ad nauseum. For example, can now the Supreme Court, which excise can make law regulating its practice procedure, make a law overriding the Parliament's making of the law? Then the Parliament will do it. Then where will we stop? So my humble submission is that could not have been the intention of the framers of the Constitution, that to give power to Parliament, because there is separation of power. Once the Honorable Supreme Court has made the rules regarding regulating the practice procedure, the Parliament does not. But that practice and procedure, the rules, cannot be in violation of any constitutional provision or any law which existed, sir.
The core question is, where does the Constitution confer, in which institution confer the power to make rules? Whether it is the Parliament or is it the Supreme Court? If it is the Supreme Court, the only restriction is that the Supreme Court can do so within the framework of the Constitution and the existing law.
My Lord.
And that's it.
Yes,
the Parliament cannot, because the power does not vest in the Constitution in the Parliament in terms of Article 199.
191, my Lord.
Next point.
Commission on this score is that that's the reason I was saying.
I would really want to hear you, Mr. Zubairi.
Sir, my Lord is asking a question.
नहीं वो आप बात तो करें फिर सवाल उठेगा
यकीनन पूछ रहे हैं इसी बात से सवाल उठाए सर जी.
Now if I may ask you, these words subject to the Constitution, if these words were not there at all and the Supreme Court were to make rules and someone were to point out, well sir, this proposed rule X is contrary to the Constitution, the answer would presumably be the Supreme Court would say, well, okay, yes, you are right, so we can't make rule X, right? So in that sense, saying subject to the Constitution is always redundant.
Yes.
Because it's always going to be there.
There.
Seems to me, but this is the question, that perhaps there is a more subtle. The Constitution, of course, can also be amended. Yes?
Yes,
under Article. But by and large, the Constitution is regarded at any given time to be fixed, right? This is it. Underneath it, whatever happens by the judiciary, by the executive, by the legislature. So maybe the point in saying subject to the Constitution is not to make the obvious point that everything is always subject to the Constitution. Everyone knows that. Rather to fix the position of law. That when the rules are being made, what you just said, when the rules are being made by saying subject to the Constitution and the law can only be as at that time.
At that time, sir, when the rules are framed.
This is the point that is being made here. Because otherwise I was thinking about this, and I've been thinking about this since the case started. Why subject to the Constitution? Because everything is always subject to the Constitution.
Mr. Zubairi, I just want to say one thing. The day we hear this case, the weeks we hear this case, our institution exceeds our disposal. The day we don't, our disposal exceeds our execution. If you think this is a never-ending hearing, this is the last day of the hearing.
My Lord.
Please remember that. You can argue till 11:30, and each one of us may have their views. Let them be expressed in judgments. I want to hear counsel.
Sir, when a question,
I mean, if you,
my Lord,
please continue. We will restrain ourselves. You just continue your argument so we can be enlightened what you want to tell us, and we can record it, and we can either agree with you or disagree with you in our judgments.
So, my Lord,
please, next point. Please go on to the next. Please go on to the next point.
So, my point is that, again, my Lord, that when the law is being given to the Parliament, so hence subject to law, and for that I want to take you, my Lord, I have placed certain case law before Lordship, if my Lord has that.
दे दिए या देंगे?
ये रखे हुए सर.
पहले से नहीं दिए?
सर दिए हैं, बहुत पहले से दिए हैं, रखे हुए हैं.
आज?
नहीं सर, मतलब उन्होंने कहा जब आप आर्ग्यू करेंगे उस वक्त दीजिएगा, मैं तो कब हर रोज लेके आ रहा हूँ सर.
Sorry, this is most unfair. हमने कहा था लोगों को फाइल कर दें.
ये केस हम जस्ट
ठीक है, you are right, we are wrong.
नहीं सर,
we have told everybody to file. हाँ भी कागज के टुकड़े आ रहे हैं बीच में से, और ये कोई आसान चीज है पढ़ना?
इस लॉ है सर, इसमें
तो पहले नहीं कर सकते थे फाइल? कहीं दुनिया में ऐसे होता है या सिर्फ निजाम अदल में ऐसा चलेगा? बाकी दुनिया की हम तारीख में बताते हैं। ये जरा प्लीज ठहर जाइए ना कि अमेरिका में क्या होता है, विलायत में होता है। आप ये करें अमेरिका विलायत में जा करके, फिर क्या होगा आपके साथ? वहां तो आप सारे वेस्टर्न ट्रेडिशंस बताते हैं, इस्लामिक ट्रेडिशंस तो बताते नहीं है। अगर कागज के मामले में ठीक है भाई, मेरी मर्जी जब मैं करूं। सच ए सीनियर काउंसिल।
माय लॉर्ड, मे आई टेक पेज 144 ऑफ दिस इज अ केस।
आप हमें प्रोपोजिशन बताएं, पहले प्रोपोजिशन बताया जाता है।
How a subject to law has to be interpreted, that is my।
ठीक है, बता दें केस का नंबर।
Its case is page 144 of this booklet, sir.
जी।
Winberry versus Salisbury. It's a case from the American jurisdiction, and they have interpreted this word, what is the meaning of, and their constitution also provided this thing.
Their constitution also permits of documents in courts. चलिए खैर 144.
Sir, this is just a case law which I'm citing.
ये सुप्रीम कोर्ट का
नहीं sir, it is Supreme Court of New Jersey, sir.
अच्छा ठीक है।
जी। My lord, page 145. If my lord kindly sees the sixth line from the top.
देखिए वो जरा मुनासिब नहीं लगता है। सुप्रीम कोर्ट ऑफ पाकिस्तान फुल बेंच में, सुप्रीम कोर्ट ऑफ न्यू जर्सी का जरा ठहर तो जाइए ना। हमें हमारा लेवल इतना लो तो ना कर दें। सुप्रीम कोर्ट ऑफ अमेरिका तो बताए, सुप्रीम कोर्ट ऑफ न्यू जर्सी को हम फॉलो करेंगे।
सर मैं सिर्फ बता रहा हूँ कि
हाँ बता दें, ज़बानी बता दें। हम आपकी बात में ज्यादा वजन है बल्कि सुप्रीम कोर्ट ऑफ न्यू जर्सी में।
उनके कॉन्स्टिट्यूशन में इस तरह का लफ्ज नहीं है, लेकिन उनके जो स्टेट्स हैं उनके कॉन्स्टिट्यूशन में इस तरह के लफ्ज हैं। काइंडली सी द सुप्रीम कोर्ट शैल मेक रूल्स गवर्निंग द एडमिशन ऑल कोर्ट्स स्टेट एंड सब्जेक्ट टू लॉ द प्रैक्टिस एंड प्रोसीजर ऑफ ऑल सच कोर्ट्स। दिस इज द लॉ व्हिच दे इंटरप्रेटेड। एंड माय लॉर्ड, इट सेज पैरा 2 ऑन पेज 145।
Phrase subject to law.
The phrase subject to law is not only ambiguous but elliptical. No
what is elliptical mean?
Sir, मतलब कि it is confusing. जी.
You reading a word? You tell us the meaning of the word.
Continuous, sir. Continuous. No word in the law has more varied meaning than the term law itself. Nor is the phrase subject to crystal clear, for the phrase implies a limitation rather than a grant of power. It is argued by plaintiffs subject to subject to statute or legislation.
It is argued. अभी judgment भी नहीं है.
जी आ रहा हूँ sir. If subject to, अब नीचे last paragraph sir. If the subject were to interpret it to mean subject to legislation, it would necessarily follow that once the legislature has passed a statute in conflict with the rule of court, the rule-making power of Supreme Court will become functus officio. For it would intolerable to hold, as has been suggested to us, that after the legislature has passed an act modifying a rule of court, the Supreme Court might in turn adopt a new role overriding the statute, and so on ad nauseum. And yet, if subject to law means subject to legislation, any other construction of rule-making power would be in conflict with fundamental rule of constitutional constraint that unless the context clearly requires otherwise, a constitutional grant of authority is to be interpreted as a continuing power. My lord, then the last three lines, paragraph page 146. All these
page 147 से पढ़ लीजिए.
जी हाँ, उसका आ रहा.
Page 147 last two lines से पढ़ लीजिए.
जी बहुत बेहतर.
वो वही आ रहा है, नीचे आ रहा है.
जी इसमें फिर सब पेज 146 पे
147 की लास्ट टू लाइन से पढ़ लीजिए ना, वो आपको थोड़ा सा उसमें जवाब मिल रहा है.
जवाब आ रहा है कि मैं कुछ आपको पॉइंट आउट करना चाह रहा हूँ कि पेज 146 के लास्ट तीन लाइंस देख लीजिए. मैं सिर्फ वो जो पॉइंट्स हैं उसको आपको दिखा दूंगा सर. इट इज conceivable that the people granted continuing power to the courts in all these respects or withheld it with reference to rule making, sir. Then, my lord, page 147.
Last two lines.
If the regime may amend the rules or it may decide the extent to which the law division charge shall exercise the powers functions of other division, it may control the degree to which legal and equitable relief may be in any cause. We think it may be safely and that no such thoughts are ever in the mind of the member of Constitutional Convention or any citizen who voted for the Constitution. Yet, if subject to law means subject to legislation, such results might inevitably follow. The courts, in some of their essential judicial operations, instead of being one of three coordinate branches of state government, would have been rendered subservient to the legislature in a fashion never contemplated by any. What then is the meaning of subject to law? The only interpretation of subject law that will not defeat the objective of the people to establish an integrated judicial system which is independent and which will at the same time give rational significance to phrase is to construe it as equivalent of substantive law as distinguished from pleading and practice. The distinction between substantive, which defines our rights and duties, and the law of pleading and practice, or through which such rights and duties are enforced in courts, is a fundamental one that is part of daily thinking of judges. Substantive law includes much more than legislation. It comprehends also the rights and duties which have come down to us through the common law. The phrase subject to law in Article 6 of the Constitution thus serves as a continuous reminder that rule-making power as to practice must not invade the field of substantive law as such. While the courts necessarily make new substantive law through the decision of specific case in Commonwealth, they are not to make substantive law wholesale through the exercise of rule-making power. That is the concept. So subject to law does not give power to legislate. It is not subject to legislation. Where it is made subject to legislation, then the Constitution uses the words make such, as pointed out. ये कई articles हैं of the Constitution, मैंने 154, 150, then 240, 241 and 242 के अंदर भी यही लफ्ज हुआ है make by law.
Mr. Abid, the law which is in dispute has been made pursuant to Article 175(2).
Yes,
this is the power.
Sir, but
so, in the law itself, pursuant to Article 175, read with Article 191. We are making much time on 191. What about Article 175? Because no court has jurisdiction unless conferred by the Constitution or the law.
Yes, but 175(2) cannot be read in isolation. That is the judgment of this court.
It is the dedicated to the judicator.
Sir, may I
so power of the court are covered under Article 175.
Read with Article 142.
That is the law that have made under pursuant to 191. Read with 191, yes, but the law has been made pursuant to Article 175. उसको पढ़े ना 2 में आपके वो jurisdiction किसी कोर्ट का jurisdiction जो है that is related and based on the premise of Article 175(2).
My lord, then provincial law भी आपके लिए province बना सकते हैं.
The courts 175. There shall be a Supreme Court of Pakistan, a High Court for each province.
And such a court as may be established by law. In no court,
Article 2,
no court shall have any jurisdiction save as is or may be conferred on it by constitution by or under any law. That is synonymous. But humble submission is that this honorable court has interpreted when it deals with the Supreme Court, it has to be read with two further articles, Article 142A and Entry 55. May I take your lordship to Article 142A?
Yes.
And that is the judgment of this honorable court, sir.
So this article, I don't understand.
It's not a standalone article, sir.
It is?
Does, no, with humble submission. That
you are now reading words into the Constitution.
No, I'm reading.
No, where does it say it's not a standalone article?
It's because the judgment of the Supreme Court says so.
You can imply it, but it doesn't say so.
Sir, I'm not saying anything of my own. I based my arguments on case law and I cite a case law on that of this honorable what they have said.
I think the whole object of a full court hearing counsel is being missed. If all we are going to do is keep referring to case law, we are sitting, the full court is sitting. I don't even think you understand the gravity of it. To understand, to learn from counsel. Yes. Refer to this judgment, refer to that judgment. Bhai, the plain words of the Constitution, you don't want to read. Then you want to read New Jersey Supreme Court. Let's read plain words of the Constitution. Let's hear counsel formulate submissions on that. Then by all means, if there is some ambiguity, we can go to precedent.
My humble submission
you see,
is that
the main rule for constitutional interpretation is that the entire Constitution has to be
read as a
whole in a context. You cannot pick up one article and just read it in isolation, because there are other articles which either may restrict or enhance that power which exists in
and
one
how that power is to be
article.
exercised. Now, what is the law they are talking about in Article 175(2)? No court conferred on it by constitution or by under any law. So the only two articles of the Constitution when it concerns the Honorable Supreme Court is Article.
ये बात बार अब Honorable Supreme Court नहीं होता है, Supreme Court Honorable Judges होते हैं. अंग्रेजी का तो सही इस्तेमाल कर लेना. Honorable Parliament नहीं कहते.
हम ये भी आप भी करते हैं. हम यही करते हुए आ रहे हैं सर.
चलिए आगे जरा पॉइंट बताएं ना आगे.
My humble submission is that Article 175(2)
जी ठीक है पॉइंट आपने कहा has to be read with
Article 142A and Entry 55.
142A and Entry 55. Let's read 142A.
Mr. Zubairi, the point it seems to me over here is the question that when we are talking Article 191, we are talking of practice and procedure. Are we really talking of the jurisdiction of the court?
No.
We are talking of a direct grant by the Constitution
of the regulation
of rule-making power with regard to practice and procedure.
Yes.
So, when in this act, in the preamble, when reference is made to Article 175(2), which relates to jurisdiction,
then you go to 142A.
What is? Would that be correct, or would that perhaps be not entirely correct? Because here we are not talking of the jurisdiction of the court, but of its practice and procedure.
बिल्कुल सर.
साहब इस कानून ने एक और काम भी तो किया है. इस कानून ने एक अपील का हक भी तो दिया है. तो वो प्रोसीजर में तो नहीं आ सकता है ना. तो वो सिर्फ 175 मेरे ज़हनियत के मुताबिक वो सिर्फ 175(2) ही में आ सकता है. उसको प्रोसीजर मैटर हम नहीं समझेंगे.
वो भी एक जुरिडिक्शनल पॉइंट है. वो 142A और Entry 55 के तहत आपको पढ़ना होगा.
बता दें हमें.
जी 142A देखें सर. Because they are not the word 175. 175 talks about jurisdiction. 142A sir.
नहीं आप शुरू से पढ़िए 142. यहाँ भी subject to the Constitution लिखा हुआ है.
मैं आ रहा हूँ सर. Subject to Constitution. मजलिस शूरा shall have.
नहीं ऊपर subject to the Constitution.
जी
अब इसका बताएं इसका क्या मतलब है?
The Constitution is subject to it. It cannot be any law cannot be in violation of any constitutional provision, existing provisions of the Constitution, sir. Majlis Shura Parliament shall have exclusive power to make laws with respect to any matter in the federal legislative list. So this power to make law, exclusive power to make laws as provided in federal legislative list, sir. And now Entry 55.
आप हम यहाँ पे इंटेंशन ऑफ द लॉ मेकर और कॉन्स्टिट्यूशन मेकर देख रहे हैं. आप कहते हैं कि रूल्स बनाने का इख्तियार दिया गया है और सिर्फ लॉ के तहत नहीं होगा जो ऑलरेडी एग्जिस्टिंग लॉ होगी. अगर आप इंटेंशन ऑफ पार्लियामेंट देखना चाहते हैं तो आप आर्टिकल 175A सब आर्टिकल 5 देख लें.
जी.
सब 4.
जी.
यहाँ पे सब्जेक्ट टू कॉन्स्टिट्यूशन और लॉ नहीं है.
जी सर.
द कमीशन में मेक रूल्स रेगुलेटिंग इट्स प्रोसीजर.
जी.
अगर इंटेंशन कॉन्स्टिट्यूशन मेकर का ये है कि वहाँ तो सब्जेक्ट कॉन्स्टिट्यूशन एंड लॉ होना चाहिए, तो यहाँ क्यों नहीं दिया गया सब्जेक्ट कॉन्स्टिट्यूशन?
Because humble submission is that
जरा पढ़ लें
जी, I'm reading it.
175A.
The commission may make rules regulating its procedure. Sir,
यहाँ तो सब्जेक्ट कॉन्स्टिट्यूशन नहीं है
सर, आपने तो
इससे इंटेंशन आप क्या करेंगे?
फुल कोर्ट ने तो सुप्रीम जुडिशियल काउंसिल की रूल मेकिंग पर रूल की कोई प्रोविजन नहीं, उस पे भी कहा है दे कैन मेक रूल्स, द सुप्रीम जुडिशियल काउंसिल कैन मेक रूल्स व्हिच विल हैव कॉन्स्टिट्यूशनल स्टेटस. ये है जजमेंट ऑफ द ऑनरेबल.
मेरा सवाल शायद मैं नहीं समझा पा
जी, मैं आप समझिए, आप कह रहे हैं
इंटेंशन देखना है
जी.
यहाँ पे तो ये कहा है विदाउट मेंशनिंग द वर्ड सब्जेक्ट टू कॉन्स्टिट्यूशन लॉ.
जी,
यहाँ सिंपल कहा है द कमीशन में मेक रूल्स.
जी,
बस तो बात समझ आती है कि आपने रूल लॉ को नहीं देखना जो एग्जिस्टिंग है या पहले से है.
जी,
वहाँ पे ये दिया गया है कि सब्जेक्ट टू कॉन्स्टिट्यूशन, ये तो अंडरस्टूड है, सब्जेक्ट टू का मतलब है उसके ताबे होने चाहिए.
जी,
अमूमन होता भी ये है कि पहले
रिस्ट्रिक्टिव वर्ड है, नॉट एनेबलिंग प्रोविजन.
पहले एक्ट बनता है उसके बाद रूल बनता है.
जी,
रूल कभी एक्ट से ऊपर नहीं होता है, ना एक्ट से हट कर होते हैं. कोई भी रूल अगर बनाया जाए वो एक्ट से, एक्ट के डोमेन से या कॉन्स्टिट्यूशन के डोमेन से बाहर होंगे तो स्ट्रेट डाउन होंगे. तो यहाँ तो ये जरा बता दे कि इंटेंशन वाज़ेह नहीं है दोनों आर्टिकल्स में.
सर, इसमें मेरा humble submission will be that in this case, sir, still no rule can be made in violation of the constitutional provision.
अब आप सवाल का जवाब या तो सवाल नहीं समझे, मैं आपके लिए आसान तरीके से बता देता हूँ. माय लॉर्ड पूछ रहे हैं आपसे कि जहाँ तक जुडिशियल कमीशन ऑफ पाकिस्तान का वहाँ ना सब्जेक्ट टू लॉ है ना सब्जेक्ट टू कॉन्स्टिट्यूशन है. इसका मतलब एक मतलब तो ये निकलता है कि ना कोई लॉ बन ही नहीं सकता है उसके मुतालिक, वो हमेशा कमीशन खुद ही बनाएगा अपने रूल्स. ये सिंपल रीडिंग है जी. और वहाँ 191 में सब्जेक्ट टू लॉ एंड कॉन्स्टिट्यूशन इसलिए लिख दिया गया कि आइन में भी हो सकता है और लॉ में भी हो सकता है. तो ये जमाल साहब की अंडरस्टैंडिंग गलत है, तो जरा समझा दीजिए.
बिल्कुल सही. मैं जो अर्ज कर रहा हूँ कि जहाँ सब्जेक्ट टू यूज होता है वर्ड, वहाँ ऑलरेडी के कोई रूल इसके वायलेशन में नहीं बन सकता, which is already existing, subject to constitution, subject to law, already substantive law exist करता है. उसमें आपकी regulation और practice and procedure पे आप
आप फिर
इसमें अगर नहीं यूज किया गया तो इसका मतलब ये इसको सब्जेक्ट ताबे नहीं किया जा रहा है.
ठीक है, ये आपका इंटरप्रिटेशन.
जी, इसको ताबे नहीं किया जा रहा है, but still no rule can be made in violation of the constitutional provision or any law.
ठीक
जी.
Mr. Zubairi, is it so that it is the only Supreme Court which can make rules under Article 199, High Court and Federal Shariat Court, they are having the same powers?
Sir, 202 of the Constitution gives the power to make rules to the High Court, sir.
And is there any law made for those two courts?
उनके अपना procedural laws हैं High Court में, and that judgment of a single bench judgment was cited by Mr. Bhandari on the last date, 2021 Lahore, which deals with what is the meaning that rules can be made, but they are no, they have to be read with NT 55 does not apply to them, because that's why the rules of law reforms ordinance की बात की थी.
Parliament has put up clog on the Supreme Court. Why not on High Court and the Federal Shariat Court?
The High Court में है
What were those
202
special
sir.
reasons to constitute this act?
Sir, 202 kindly be seen. Subject to constitution and law, a High Court may make rules regulating the practice and procedure or of any court subordinate to it. So
203J is the Federal Shariat Court.
नहीं, आप माय लॉर्ड का सवाल नहीं समझे. आपका पहले वाले सवाल का जवाब ये था क्योंकि रूल्स बन गए हैं तो अब सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ has been rendered effectively meaningless. माय लॉर्ड का सवाल ये है, अगर आपकी ये बात सही है तो सुप्रीम हाई कोर्ट के कौन से रूल्स और फेडरल शरीयत कोर्ट के कौन से रूल्स बन गए थे? ये फिर इसका जवाब क्या होगा? ये मैं इसका जवाब आपने नहीं दिया.
सर, पहले मैं आपकी बात का वो जवाब दे दूं.
नहीं, मैंने सवाल नहीं पूछा, मैं सिर्फ आपको माय लॉर्ड का सवाल बता रहा हूं.
आपने कहा कि अब नहीं, मैं अभी भी कहता हूं आज आप रूल्स बनाने जाएं, they cannot be in violation of the constitution. Subject, they have to be subject to any substantive law.
I can only use one word for it, profound.
जी, but still आपने ये कहा कि मैं कह रहा हूं कि जी अब नहीं हो सकता. My lord, rule making power is a continuous power.
मगर माय लॉर्ड का जवाब नहीं दिया आपने.
जी, मैं दे रहा हूं उस पे सर. इसके अंदर भी जो लॉ उन्होंने बनाया है, that has to be subject to constitution and the law, and that is the interpretation given in the judgment of.
इसके लिए तो कोई legislation नहीं है.
The Lahore High Court in a full bench judgment, जब ये क्वेश्चन राइज हुआ था कि गवर्नमेंट ने भी लेजिस्लेशन कर दी थी और हाई कोर्ट ने रूल्स भी बना दिए थे, the High Court said you cannot do that.
Do that. जी.
Once the power vests in the High Court, the government or the legislature cannot legislate in matters relating to rules because the rule-making power exclusively vests in the High Court.
जी. So this is judgment जिस पे आई PLD 2021 Lahore page 544 and relevant portion is para 61 page 580 onwards sir.
पढ़िए
PLD दोबारा साइटेशन बताइए
PLD 2021 Lahore page 544 my lord para 61
आपकी बुक में कौन सा हिस्सा है
पेज 580 पेज 561
की बुकलेट में कौन सा है
जी बुकलेट में नहीं है सर मेरे नोट्स भी हैं मैंने अपनी सीएमए भी दाखिल की हुई है पर क्योंकि माय लॉर्ड ने पूछा तो इसलिए मैं निकाल के पैरा 61 और बात 202 पहले कोट करते हैं और फिर मैं आई रीड दिस पैराग्राफ सर
ये पेज 544 आप
580 सर it starts at page 544 and relevant portion which my lord's observation is at page 580
सिंगल बेंच का जजमेंट है
जी
why you are citing it before full bench
तो इसमें इंटरप्रेट हुआ है हाई कोर्ट की पावर्स के ऊपर जो 202 की पावर्स हैं जी
सिंगल बेंच का जजमेंट फुल कोर्ट को साइड क्या फर्क पड़ता है क्यों नहीं पड़ता
इसमें एक लॉ बना दिया था अमेंडमेंट लॉ और रूल्स में अमेंडमेंट कर दी थी दैट वाज चैलेंज एंड दैट वाज सेट असाइड काइंडली may I read lordship's kind permission
you want to
जी thus the high court have been conferred the constitutional power regarding rules and procedure which may not only regulate the practice and procedure of a high court but also any court subject to it. In exercise of this power HC has made rules entitled High Court Rules and Orders which contains elaborate procedure to be followed by the court subordinate to it in matters relating to adjudication of cases before civil court. Thus, not only has the High Court been delegated the power of making and amending rules in the first schedule by the court itself, but also by the Constitution by virtue of Article 202. The central question regarding power of High Court has escaped the attention of Government of Punjab while promulgating the amendment ordinance which impinges upon the powers of Lahore High Court to enact and amend the rules. This proposition being stated for a simple reason that the amendments to by amendment ordinance are made part of the substantive body of the court, not in the rules comprised of first schedule, and also, almost all of them relate to details of procedure to be followed by civil courts in adjudication of cases, which as numbered has traditionally been part of first schedule. A grossly egregious and anomalous situation has now been created with pits and procedure introduced by amendment against the amendments made by Lahore High Court, which now run a parallel course. There are serious contradictions between the two processes, which is most cases are irreconciled. Although, I'm reading from the last line, although in such matters considered as is not normally assigned, but in peculiar case where across the board amendments the rules have been made by committee of the High Court only a few months, Government of Punjab is obligated to have consulted LC for purpose of reconciliation. Also, while the reference to Article 2 of the Constitution has already been made, it also by implication follows that exercise of rule-making powers is constitutional, which resides in the High Court. Therefore, if such power has already been exercised, emerges as an unwritten rule to be followed in all such matters that is of utmost importance concern be held and the government of province. It is not only essential but also to preserve the independence of that is unique situation where judicial legislation is permissible. So this is the thing that once the constitutional power has been exercised by the court, because these rules made by this court have constitutional backing, this is what the judgments have said, it has constitutional backing. Even the rules under the Supreme Judicial Council, PLD 2021 Supreme Court page 1, page 94 says that though Supreme Judicial Council does not, the law does not permit, allows them to make rules, but they made the rules, Supreme Judicial Council, and those rules have constitutional status.
So it's very look at Article 203E in relation to the Federal Sharia Court.
Ji.
Take a look at Clause 2. 203 capital E, Clause 2.
My Lord. Yes, my Lord. The court shall have power to conduct its proceeding and regulates its procedure in all respect as it deems fit.
This doesn't seem to be regulated by law.
No, it doesn't, sir.
So therefore, does this mean that the rule-making power of the Federal Sharia Court is on a higher pedestal as compared to the Supreme Court or the High Court?
No, my humble submission, both are constitutional powers, sir.
So,
both the Supreme Court, the High Court have been granted.
I'm just coming off from what my learned colleague was asking you about the rule-making power of Federal Sharia Court. If read literally, this would mean that the Federal Sharia Court is put on a pedestal much higher than even the Court, to which appeals lie from the Federal Shariat Court.
So then there are judgments of this Honorable Court that if there's a conflict between a substantive provision and provision of the Federal Shariat Court, then those substantive provisions will prevail, sir. So that is also a judgment of this Honorable Court on this field. That constitutional provision will be higher pedestal than the provisions under the Federal Shariat Court chapter, sir.
Thank you.
Ji, my lord. So my submission is that I was coming to that the jurisdiction aspect, sir. Jurisdiction aspect is that yes, Article 175 gives the Parliament the jurisdiction to make law, but that law has to be read with Article 142A, which I read to your lordship, sir, and entry 55, sir.
191 confer jurisdiction or does it confer power?
I'd say it confers power, sir, because it says regulated. The most important word is that the rule make it regulate the procedure, the practice and procedure. What is the meaning of regulate?
91 is not a jurisdiction conferring article.
It is conferring power.
Conferring article. And there is a between jurisdiction and power.
And that has been very elaborately dealt with by this Honorable Court in Ziaur Rahman's case, sir. PLD 1973 Supreme Court, page 49, and the relevant question is, okay, what is the difference between judicial power and jurisdiction, sir?
PLD 73
Supreme Court, page 49, sir. And I'll give you lordship the citation. Is faced by the local government. So basically it is a restrictive thing and says that it's a bar, not a enabling provision for legislation. Then what is the meaning of subject to law? My humble submission is that subject to law does not mean it implies the implementation rather than grant of power, number one. It doesn't imply, it implies rather than grant of power. If rule-making power is made subject to legislation, sir, then the rule-making power of Supreme Court will become functus officio. Constitutional grant of rule-making power is construed as a continuing power, sir. So there cannot be any limitations on that, or constitutional power given that. It is not an enabling provision. Subject cannot mean subject to legislation, sir. As subject law is interpreted, the Supreme Court's rule-making power are subject to then, that would be a grave violation of independence and separation of powers doctrine, sir. Subject law means substantive law. Subject to law means substantive law as distinguished from pleading and practice. Substantive law includes much more than legislation. It includes common law. Subject to law means power as to practice must not invade the field of substantive.
To section 6, the answer lies in Article 188, read with Article 199. So, with your lordship's permission, I'll read Article 188.
Mike,
Ji, farmaiye.
Article 188, review of judgments and orders by the Supreme Court. The Supreme Court shall have power, subject to the provisions of any act of Majlis-e-Shura, Parliament, and of any rules made by the Supreme Court to review any judgment and order. Act of Majlis-e-Shura or Parliament, not law. While coming to Article 191, subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the court. Now, my lord, the framers of the constitutions were clear in their mind that they wanted to confer the legislative power upon the Parliament to have a law for the review, but not for the practice and procedure, my lord. And the wisdom might be, the wisdom might be that in review, right of a party is involved, while practice and procedure is the internal matter of the apex court.
But counsel, review के ऊपर भी there is already a provision in the Practice and Procedure Act, and review का जो Section 6 आपने पढ़ा है, that relates to a question of procedure. So where the procedure is already provided, and it has been argued with some force that the power to make procedure and rules and procedures vests exclusively with the Supreme Court to the exclusion of any other organ. Then, once that procedure has been provided, another procedure cannot be provided by the Parliament to override that procedure. That is the argument made. What is your answer to that?
My Lord, I totally bow before that observation, but my submission is that only to the extent of legislative competence, the Parliament has the domain. The Parliament, in principle, can provide for a law regulating the review, but not the practice and procedure. Otherwise, the term Parliament or Majlis Shura should have been used in 191, which is not the case, my Lord. This is my first submission. And Honorable Justice Jamal Khan Mandukhail had the my Lord, question.
Other point?
Other point is that, my Lord, this conferring of domain or competence, legislative competence upon the Majlis Shura without having a specific item number in the federal legislative list or the substantial part of the Constitution, it means we are giving the Parliament a power which it did not have, and that has broader implications for the federation and the federal structure, my Lord. Lordships would appreciate that father of the nation wanted a federal state, and he wanted autonomy of the federating units. We are, my lords, interwoven in a very delicate and complex relationship. And what guarantees the autonomy of the federating units is the fact that there is a federal legislative list, there is no provincial legislative list, and the concurrent legislative list is gone. So anything which is neither in the federal legislative list nor in the substantive part of the Constitution is a provincial matter, my Lord. So, if this Honorable Court gives the Parliament the power to enact on a subject which may not be there in the federal legislative list or the substantive part of the Constitution at the garb of item number 57 and 58, or at the garb of incidental and ancillary powers, it means that the Parliament may encroach upon the provincial subjects.
पहले नेक्स्ट पॉइंट, ये तो आर्ग्यूमेंट अजीब सा है, तो आपका कहना है कि 4 सूबे अपने अपने कानून बना सकते हैं?
ये नहीं है मेरा.
तो ये आप यही कह रहे हैं?
No, my lord. Residuary matters. There is no provincial legislative list.
हमें पता है ना, इस कानून की बात करें ना.
My lord, it has implications. It has implications, and these are not remote implications. These are immediate implications.
अगला पॉइंट बताएं.
So the submission is, the prime submission pertains to the legislative competence or the legislative incompetence of the federal legislature, my lord. My second submission is that, and it was pointed out by Honorable Justice Musarati Lali in the form of a question.
Please, direct argue करिए.
My lord, answers भी दो. Brief मैं time नहीं लूँगा. That apparently, by virtue of the act in question, the office of the Chief Justice has been done away with. It has been abolished for all practical purposes, my lords. And lordships would appreciate that as per definition given by Article 176.
Before you say this, first say which provisions of the Constitution create the office of the Chief Justice, which has been abolished.
My lord, 176 defines the Supreme Court, which says that the Supreme Court shall comprise of the Chief Justice and judges, as many judges as determined by the Parliament or Presidential Act. So the institution stands on two limbs, office of the Chief Justice and judges, my lord.
आपकी अगर ये बात मान ली जाए तो आप कहते हैं कि चीफ जस्टिस और जजेस अलग-अलग नहीं है, एक ही है।
My lord,
और अगर एक ही है तो फिर क्या चीफ जस्टिस अकेले रोस्टर बना सकता है?
My lord, रोस्टर बनाने से पहले मैं एक अर्ज कर लूँ, my lord. We hear that the Chief Justice is senior among equals. While sitting in the judicial capacity,
let's not go over. Point
पे आ रहा हूँ, my lord. While sitting in judicial capacity, he is equal among the equals. What makes him senior among equals is administration. Now, what has been done through this?
There are certain powers specifically bestowed on the Chief Justice in the Constitution.
May I refer to them, my lord?
Yes, there's some powers have been specifically bestowed on the Chief Justice.
Thank you, my lord. I'm referring to them. Some of the powers, my lord. Article 183(2).
The specific mention is of Chief Justice.
Seat of the Supreme Court, Clause 2. The Supreme Court may from time to time sit in such other places as the Chief Justice of Pakistan, with the approval of the President, may appoint. This
is destructive of your argument. Here the Chief Justice has been given this power, not the Supreme Court.
Yes, my lord. Yes, my lord. Because it is at the administrative powers. It is the indication that the Chief Justice is the master of the rules. He is a pater familias. This is the first indication.
ये लफ्ज इस्तेमाल हो रहे हैं, मगर ये आइन में नहीं है, केस लॉ में है।
आइन में यह है कि Chief Justice on his own, without any consultation, without any recommendation of the committee, shall appoint the place of sitting.
Correct.
Yes,
because the Constitution says so.
So administratively, the Chief Justice has at least some say. While the impugned act, मैं दूसरे provision पे आता हूँ, my lord.
Benches के हवाले से वकील साहब with the approval of President.
Yes.
सर्किट बनते हैं ना?
Yes.
ये उसके हवाले से. और ये constitutional provision है, इसके लिए rule की जरूरत नहीं.
Yes, my lord. No rule is required.
इसका notification होता है.
Yes, my lord. Yes, my lord. But under the Constitution.
इस सिलसिले में नहीं है जो आप बात कर रहे हैं।
तो बेंच बनाने का पावर है, बेंच का पावर विद द अप्रूवल ऑफ प्रेसिडेंट होगा, और उसके लिए रूल तो वही अप्लाई होंगे जो ऑलरेडी पहले से रूल इन फोर्स है, ठीक है?
Exactly, my lord, exactly. But now, Article 10, Clause 1, Roman 1, Federal Review Board. Article 10, 1, Roman 1, after the explanation in the bottom.
Article 10 का.
जी हाँ, Chief Justice का जिक्र है.
In the case of a person, is that before your lordship? In the case of a person detained under a federal law, a board appointed by the Chief Justice Pakistan and consisting of a chairman and two other persons, each of whom is or has been a judge of the Supreme Court or a High Court. Now, for all practical purposes, this is a bench to be constituted by the Chief Justice of Pakistan, my lord.
This is not bench of the Supreme Court. This is not a bench of the Supreme Court.
Not strict to censor. But a forum is appointed by the Chief Justice.
We are talking about the bench constitution, composition of the benches of the Supreme Court.
मैं एक अर्ज कर रहा हूँ, जो पॉइंट मैं बता रहा हूँ वो ये है कि under the Constitution, in the administrative matters, the Chief Justice is on the driving seat. Now I'm referring to Article 146(3), 152, 159, Clause 3. This is only for reference. I'm not reading, my lord. 146(3), 152 and 159, Clause 4. 152 and 159, Clause 4. Under these provisions,
152 or
159(4).
Class 4. G.
Under these provisions of the Constitution, the Chief Justice is empowered to appoint an arbitrator in certain fiscal matters, in certain disputes, my lord. Now, under the original Constitution, prior to the 22nd Amendment, the Chief Justice was empowered to appoint a caretaker, Chief Election Commissioner out of the judges of the Supreme Court. Under the original Constitution, prior to the 17th and 18th Amendment, the Chief Justice alone acted as a consultee for appointments in the judiciary.
What is the point you're making?
My point is, my lord, that when we say that the Chief Justice is senior among equals, what distinguishes the Chief Justice from the judges? Administration. Otherwise, the Chief Justice would be equal among equals.
Okay, but you are saying that because these specific provisions of the Constitution specifically mention Chief Justice, so by analogy, he has other powers as well. That's what I've understood from your argument.
By analogy, he is the senior among equals.
Okay.
And you see, where there is a power under 191 to frame rules, the rules are for the purposes, administrative purposes. And in addition to the rules, there are constitutional or there are conventions of the court which have invariably been followed since since the 1956 Constitution, and before that the Government of India Act. So those conventions have also acquired the place of rules, or for that matter the procedure of the court.
Yes, my lord. Article 268(7) is very much clear to that extent, that anything having the force of law has been deemed as law.
Yes,
my lord.
268(7).
268(7), my lord. Now, what this law has done, the law does not say that the Chief Justice, in consultation with the two senior judges, shall constitute a bench. No. Had it been so, it would be least objectionable. What has been done, my lord, that any two of the three may constitute a bench. So the office of the Chief Justice has been converted into that of a senior judge, or the positions of the senior two judges have been converted into quasi-chief justices. This is my submission, my lord. There is no consultation. While concluding the arguments on the previous hearing, your lordship mentioned to the preamble, Article 2, Article 2A, 227, and I'm grateful that your lordship referred to the Grun norm. No consultation is there in this law, my lord. No consultation. And one potential deadlock which I see, not today, say 50 years from now, my lord, the two judges on one side, the Chief Justice on the other side, 50 years from now, the two decide.
Why 50 years from now? Why not tomorrow?
Not regarding the incumbent.
चलें आगे बढ़े ना आगे
मैं एक potential
आप इतना लंबा तमलीग बांध रहे हैं
मैं 5 मिनट में
चलिए कह दीजिए
if the two judges are
हाँ ठीक है तो it be a minority big deal
and the two decide,
so what,
that my honorable the Chief Justice, we have established, we have created a roster, and according to that, for the next month you will do the chamber work.
ठीक.
You will not sit on the bench. So the office of the Chief Justice has been paralyzed, my lord.
The Chief Justice can do so himself.
I'm not saying, my lord.
It implies the Chief Justice can do so, it's okay.
I'm not saying
but if two senior judges do so, it's wrong.
My lord, there cannot be any.
या तो कहें कि कर ही नहीं सकते हैं तो बात खत्म हो
There
गई.
cannot be any Supreme Court without the Chief Justice. This is my point.
We know that because the Constitution says
the Constitution says.
Yes.
And that would tantamount to sending the Chief Justice on forced leave. Such like enactment made by a dictator has already been nullified.
तो इसका मतलब ये हुआ कि अगर चीफ जस्टिस के पास पावर हो और वो कहते कि ये दो जजेस जो है ये अगले 1 महीने तक चैम्बर वर्क करेंगे,
अगर कोई डिफिशिएंसी है रूल्स में,
अगर में चले तो अगर ये भी हो सकता है.
agar deficiency, I'm not saying, I'm not going to the wisdom of this law. I'm referring to the potential dead end we may go into.
ठीक लर्नड काउंसिल आपने अभी तक आप फ्यूचर का बता रहे हैं एज द लॉ स्टैंड्स टुडे हाउ आर यू इनकन्वीनियंस्ड आपका कौन सा पर्सनल राइट जो है इन्फ्रिंज हुआ है एंड व्हाट फंडामेंटल राइट आर यू ट्राइंग टू enforce before us?
That question goes to the maintainability of the petition, my lord. And except for 3, all fundamental rights are subject to law, subject to reasonable restriction imposed by law.
आपसे simple ये question, either say yes or no. Are you inconvenienced by this law?
Yes.
Has any fundamental right of yours, has it been infringed?
Yes,
and
my
please
lord.
kindly tell us what fundamental right are you trying to enforce?
Yes, my lord. I'm referring to that.
You don't want.
I have the
you
prime
don't
right.
want access to justice to be.
No.
कुछ और infringement बता रहे हैं, बताइए.
Yes, my lord. All fundamental rights except for the dignity of man and forced labor and slavery, all have been subjected to law. Now the law means
dignity of
validly passed law. Validly passed law coming from a competent legislature, that I may not be subjected to a law for which the respective legislature is not competent. This is all fundamental rights are involved, my lord. And the mother of fundamental rights, Article 4.
ये infringement का बताइए ना कौन सा fundamental right infringe हुआ?
My lord, if the law is maintained without the necessary legislative competence, it means I'm subjected to a law for which the parliament was not competent. So it is going to affect every fundamental right.
ठीक. और कोई point?
Now, furthermore, under the constitution, all judges are equal, my lord.
जब कह चुके हैं
आगे बढ़े ना.
मैं आगे बढ़ता हूँ.
अब हमें कोई लेक्चर ना दीजिए, लॉ स्कूल में देना चाहिए, प्लीज.
ठीक है, मैं अपील पे बहुत कुछ कहा जा चुका. मैं सिर्फ एक पोटेंशियल मिसयूज, एक पोटेंशियल. My lord, under the impugned act, the committee of 3 judges may themselves sit in a bench constituted under Article 184(3). Now the judgment comes and there is an appeal stage. Now the same committee will decide as to who should hear the appeal against our judgment.
So what's wrong with that?
My lord, it amounts to appealing unto Caesar against Caesar. There is a potential conflict of interest. If I would have been a judge, I would have an interest that my judgment is preserved.
When you become a judge, we can look into it.
No. So this.
बस.
And my lord, मैं दो points करता हूँ. As per section 77 of the Act, which says that every case having urgency or where there is a prayer for interim relief shall be fixed within 14 days. Hardly there would be a case in which there is no prayer for interim relief. So if
what?
In which there is no prayer for interim relief. Almost every case has a prayer.
I think you're mixing up the concept of interim relief with urgency.
The word interim relief has also been used.
ठीक है, okay. So we can apply a brain, which we do occasionally.
Okay.
And we can determine what is urgent and what is not urgent. So what's the big deal about it?
What is objectionable? What is objectionable? That the affairs of the apex court have been micromanaged. Even the civil court ordinance, even the CPC doesn't micromanage the affairs of a civil judge. It is in this way contemptuous. It is insulting. Throughout the world, we have phrases like case management, court management. These are the inherent powers. These are always left to the court, let alone the apex court.
Actually, I'll tell you what we did. I've constituted a committee for case management. So I've given my powers already to a case management committee. So you are saying that act of mine is unconstitutional.
No, my
Because only I can do it myself, or the full court can do it.
No, my lord. It is for this honorable court to do case management. Whoever is delegated that function, it is. But the law cannot micromanage those affairs.
Okay. Chaliye, next point.
Now,
your point is that by enacting this law, a power of micromanagement has been conferred on the Parliament, which would open the door for it to micromanage not only these things, but subsequently any other thing that it needs to interfere with.
Yes, ma'am.
And that would affect the separation of powers and the independence of the judiciary.
Yes, my lord. And in legal philosophy, it is called the slippery slope theory.
Sorry?
Slippery slope.
Slippery slope.
Yes, my lords. Once you are on a slippery slope. Now, concluding my...
Learned Counsel, there was a judgment from the Peshawar High Court regarding the internment centers. For the last 4 years, that petition is pending before this court. And the Chief Justice felt, many Chief Justices, that that was not an important case enough to be fixed before the court. So you justify that? You justify the exercise of such power? And that the Parliament is bereft of jurisdiction not to come to the rescue and ensure access to justice by merely regulating a discretion of the Chief Justice? Do you defend that, justify that?
I am the effectee of that case. I am a petitioner. I am a counsel in that case, my lord.
Are you justifying it?
That again goes to the wisdom of this law. Wisdom is always with
If you are an effectee of that case and I tell you I will never fix that case, what will you do?
That would, if
to answer the question. I'm telling you, I'm saying it, I'll give you the exact proposition.
That would tantamount to violating the Constitution. Article 37.
What is your remedy?
37 says.
What is your remedy?
My lord, Article 37 says that there should be inexpensive and expeditious justice.
So what is your remedy?
That is tantamount to breaching the oath.
Yes, what is your remedy? File a reference against me.
So my lord, if...
What will you do? Tell me.
I'll file early hearing applications.
I'm dismissed. I dismiss.
And if it
I dismiss, then what will you do?
If at all it was expedient, the Constitution should have been amended. Article 55A, for instance, should have been inserted. Titled Practice and Procedure of the Supreme Court. My final submission, my lord. As I said that your lordship referred to the supreme law, the Quran and Sunnah. Now, consultation is a good thing. Nothing has restrained the Chief Justice from consulting his colleagues. But this law doesn't have a single word regarding consultation. And another thing, I can proclaim with pride that those were the Muslims who introduced the office of the Chief Justice. Imam Abu Yusuf was the first Chief Justice of human history. And he was not the appellate court.
Why was he the first Chief Justice? Do you know the story? That you don't know.
I don't know the story.
Yes, because the person who was nominated did not want to become Chief Justice. ये भी बताए ना फिर और उनको कोड़े खाना पड़े कि बनना नहीं चाहते थे मैं इस काबिल नहीं हूँ उनसे कहा गया आप झूठ बोलते हैं कि आप झूठे को चीफ जस्टिस बनाएंगे फिर ऐसे आप बात ना करें मगर मुझे इस्लामी तारीख में ये बता दें कि अपील का हक नहीं है कोई ऐसा कानून है या शरई असूल है कि अपील का हक एक दफा काजी ने फैसला कर दिया आखिर है कि अपील का कोई हक नहीं है ऑफिस ऑफ चीफ जस्टिस बनने का मकसद ये होगा कि अपील का हक है
He was the administrative head
भाई
of all
अपील के हक की बात कर रहा हूँ अपील के हक की बात कर रहा हूँ
अपील के हक में my lord प्रो एंड कॉन्ट्रा आ रहा है
प्रो बता दें मुझे एक कौन बता दें
अल इज्तिहाद ला यनक़दु बिइज्तिहादिन आखिर once an analogy is made that cannot be set aside by another analogy so वो है
बात अलग है वो लोअर और ऊपर फोरम की बात होती है ना उसमें भी इस्लामिक जूरिस्प्रूडेंस इस्लामिक शरिया में there were tiers of courts
but the Qazi al-Qudah he was the administrative head of the whole judiciary of the time
جی آپ کوئی ریفرنس کہیں گے؟ بس آپ نے کہہ دی
that is without
کتاب شتاب کا حوالہ دینا فرمائیں گے یا نہیں؟
ڈاکٹر غازی صاحب ادب
بھائی آپ کوئی کتاب دینا حوالہ دیں گے یا بس ایسے ہی کہہ دیا؟
ڈاکٹر محمود احمد
ہمیں نہیں پتا، آپ ہمیں کتاب
دکھائیے. ادب القاضی
دیجئے.
میں دوں گا مطلب.
کب دیں گے؟
میں جناب کو دس از ایکیڈیمک کوسچن.
نہیں ایکیڈیمک امریکہ کے لیے تو ایکیڈیمک نہیں ہے، نیوز جرسی کے کیسز کو، مگر ہم اپنی باری اسلام کی بات کرتے ہیں تو پھر ایکیڈیمک ہو جاتا ہے.
ایکیڈیمک نہیں، میں نے تو
بتاتے ہی نہیں، پھر آپ ریفرنس دیں نا، پھر ہم لکھیں نوٹ کریں گے.
ادب القاضی محمود احمد، ڈاکٹر محمود احمد غازی مائی لارڈ. سو ود دیز سبمیشنز ان نٹ شیل.
چلیں، تھینک یو.
آئی ایم گریٹفل سر.
کوئی رہ گیا اس طرف؟ اور آپ کو سنا نہیں تھا پہلے؟
نہیں بالکل نہیں.
آپ وکیل ہیں یا خود ہیں پٹیشنر؟
ان پرسن.
جی
ان پرسن.
جی
آپ کی پٹیشن کا ٹائٹل کیا ہے؟
یور کانسٹیٹیوشن پٹیشن نمبر 18
جی
محمد شاہدران ایڈوکیٹ ورسز فیڈریشن آف پاکستان.
اوکے.
یہ میں نے عرض بھی کیا تھا، یہ 2 پیجز پہ اردو میں ہے.
آپ نے تو کہا تھا پڑھ لیجئے گا، مجھے اور کچھ نہیں کہنا ہے.
نہیں میں نے نہیں کہا.
اچھا وہ کسی اور نے کہا تھا، ٹھیک ہے. ہاں وہ وردک صاحب نے کہا تھا، ٹھیک. 18 نمبر. جی فرمائیے.
یور آنر، یہ جو اپیل کے اوپر ہی آ جاتے ہیں زیادہ، جو فوکس کیا ہوا ہے اپیل کو. اپیل کسی بھی ہرارکی میں، آپ سیشن کورٹ سے لے کے ہائی کورٹ، سپریم کورٹ، کہیں پر بھی دیکھ لیں، کسی کو حق نہیں دیا گیا ہے کہ ایک کورٹ کے اندر ہی اپیل ہو، سوائے یہ وہ جو لا ریفارم آرڈیننس. لا ریفارم آرڈیننس میں آرٹیکل 199 میں اپیل کا رائٹ دیا، باقی کسی جگہ پر نہیں دیا گیا. ایک بات. اور
وہ لا ریفارم آرڈیننس غلط ہے.
یوران میں
کنکلوڈ تو کریں نا بات کو.
کنکلوڈ کرتا ہوں جناب، لیکن میں ساتھ میں یہ بھی ساتھ میں ایک لفظ
پہلے بتائیں وہ غلط قانون ہے، غیر آئینی ہے، بتا دیں، کہہ دیں یا کہیں کہ ٹھیک ہے.
چلیں یوران میں اسی کی ایک اور فردر بات کرتا ہوں.
دیکھیں ایسے آرگومنٹ نہیں کریں نا،
میں اسی
بات کریں، پوری بات کر لیں.
لیکن جو اس میں اپیل ہوتی ہے وہ سیم ججز کے پاس نہیں ہوتی. اگر کسی نے فیصلہ کیا ہے تو وہ دوسرے ججز کے پاس جاتا ہے.
یقیناً حضور، اس میں تو کوئی دو رائے نہیں ہو سکتی.
ابھی جو آپ لاسٹ میں وہ بات کر رہے تھے کہ اگر 15 ججز فیصلہ دیتے ہیں تو پھر اپیل کس کے پاس جائے گی؟
نہیں ہوگی کسی کے پاس، اللہ تعالیٰ کے پاس ہوگی. پھر
یہی بات ہے نا،
کبھی تو ختم ہوگی نا بات.
بالکل یہ ہونی چاہیے. دیکھیں جی، یہ اس کورٹ سے ایکسپیکٹ کیا جاتا ہے کہ دس از دی ایپکس کورٹ آف دی کنٹری.
اچھا سردار صاحب کہہ رہے ہیں کنٹیمپٹ آف کورٹ میں بھی اپیل ہے، وہ بھی تو اسی عدالت میں.
کنٹیمپٹ آف کورٹ میں جو
اور اس عدالت کا فیصلہ ہے وہ جو کم ججز نے کیا پرسائڈر نے کیا.
انٹرا کورٹ اپیل ہے وکیل صاحب، سندھ میں بھی ہے، یہ سندھ ہائی کورٹ میں بھی ہے. ادھر دیکھیے 1980 سول کوڈ امینڈمنٹ کے تحت انٹرا کورٹ اپیل سندھ ہائی کورٹ میں بھی ہے. سنگل جج کے فیصلے کے خلاف ٹی بی میں اپیل ہوتی ہے، ہائی کورٹ اپیل کہلاتی ہے. وہ لاہور میں، اسلام آباد میں آئی سی ہے، انٹرا کورٹ اپیل، بالکل انڈر دی لا ریفارمز آرڈیننس 1972. تو وہ جج تھوڑی سنتا ہے جس نے اوریجنل فیصلہ کیا ہوتا ہے، وہ تو ڈی بی بنے گی، سنگل کا فیصلہ ڈی بی میں جائے گا اپیل میں.
سیم جج اس کے پاس نہیں جاتا ہے. آئی سی میں ججز ڈفرنٹ ہو جاتے ہیں.
ظاہر ہے ڈفرنٹ ہوں گے نا، تو یہاں بھی ڈفرنٹ ہوں گے نا.
ایک تو یہ ہرڈل
یہاں پہ 184(3) میں 3 ججوں نے ڈیسائیڈ کیا ہے اور رائٹ آف اپیل دی گئی ہے، تو وہ 3 تھوڑی بیٹھیں گے اس میں سننے کے لیے.
ریویو میں وہی سنیں گے، اپیل میں کوئی اور سنے گا. یہ تو یہ آپ چاہتے ہیں ہم تو یہ تو ہم تشریح کر دیں گے، یہ تو آبویس سی بات ہے.
بالکل اس کی تشریح بھی ہونی چاہیے.
اچھا ٹھیک ہے، اور کیا پوائنٹ ہے آپ کا؟
یور آنر، تمام اپیلیں جو ہیں جو اس کورٹ میں ہوتی ہیں، تمام اپیلیں جو اس کورٹ میں ہوتی ہیں، ٹربیونل کی اپیلیں 212 میں یا جو بھی کنٹیمپٹ میں ہوتی ہیں، وہ تمام اپیلیں جو ہیں 185 کے ساتھ ہوتی ہیں. 185 کے علیحدہ نہیں ہوتی، اس میں ٹائٹل 185 ہوتا ہے ریڈ وتھ. تو کیا 184 کو بھی 185 میں ہم لائیں گے؟
اب سوال پوچھیں گے، ہم اپنا ججمنٹ میں آپ کو جواب دے دیں گے.
یہ بالکل یہ میں نے ریز کر دیا نا جناب، میں نے ایک آئینی سوال ریز کر دیا نا.
ٹھیک ہے، ہم جواب دے دیں گے آپ کو.
آج تک جتنی اپیلیں ہوئی ہیں نا سپریم کورٹ میں نے وہ اس کا پتہ کر کے آیا ہوں کہ وہ میں اے آر سے بھی پتہ کیا کہ وہ 185 میں ہی آتی ہیں، چاہے وہ
ٹھیک.
تو آپ کہنا کیا چاہتے ہیں کہ آپ کہتے ہیں کہ ان کو تو اپیل کی ریمیڈی ہے کہ 184 میں ہونی چاہیے یا نہیں ہونی چاہیے، یا 184
میں یہ کہنا چاہتا ہوں
ہوں کہ اگر دیکھیں نا 212 جو ایک آرٹیکل ہے
اس میں اپیل ہے، اس کے بارے میں کیا کہتے ہیں؟
اس میں اپیل ہے تو اس میں کیوں نہیں دی گئی؟ پھر 184 میں کیوں نہیں دی؟ جنہوں نے دیکھیں یہ جو آئین بنایا ہے یہ کانسٹیٹیوئنٹ اسمبلی نے
آپ جواب سننا چاہتے ہیں؟ ذرا جواب لمبا ہو جائے گا
جی.
پھر اگر یہ جواب آپ کو شاید پسند ہی نہیں آئے.
نہیں میں اس کے لیے بھی تیار ہوں.
اچھا سن لیجئے پھر.
ہاں
یہ ایشو کبھی پہلے کیوں نہیں رائز ہوا؟ 73 کا آئین ہے نا
یور آنر.
184 کا اختیار 184(3) کا جو اختیارات زیادہ استعمال کیے گئے کب استعمال کیے گئے؟ 73 میں، 74 میں، 75 میں، 76 میں، 77 میں کب پہلا اختیار استعمال ہوا؟ وہ ہوتا تھا ایک جنرل لوگوں کی انفورسمنٹ آف فنڈامنٹل رائٹ کے لیے. ٹھیک ہے نا؟ اب شاید ہم نے تجاوز کر دیا خود ہی 184(3) میں سے، شاید، یا تو آپ کہیں نہیں کیا. آپ کے سارے ججمنٹ 184(3) کے بہت اچھے ہیں، مفید ہیں، سب کے لیے فائدے مند ہیں، وہ تو ایک بحث ہوگی. تو جہاں ہم تجاوز خود کر رہے ہیں، آپ نے کہا کر تو دیا تو خیر ہے، مگر اس کا کوئی سلوشن بھی نہیں ہے. صرف آئین کو آپ ترمیم کر لیں. آئین میں ترمیم کرنا ایسا آرام سے بات کہنا، آپ 2/3 اکثریت لائیے نا. آپ یہاں کر کے کھڑے ہو کر کے باہر کے الیکشن لڑنا ایک مشکل ہو جاتا ہے جیتنا. وہاں 2/3 الیکشن لانا کوئی آسان کام نہیں ہوتا ہے کہ پارلیمنٹ میں جی کر لیں، صرف کانسٹیٹیوشن امینڈمنٹ کر لیں. تو پہلے آپ کہیں کہ جی تجاوز تو آپ نے کر لیا، اس پہ تو اس کو تو چھوڑ. میں وہ جملہ نہیں استعمال کرنا چاہتا ہوں جو عام فہم میں استعمال کرتے ہیں، وہ تو ہو گیا درگزر کریں، مگر غلطی تو کر دی. اب ہماری غلطی صرف 2/3 پارلیمان کر سکتی ہے. 3 ججز کی غلطی یعنی کہ 400-500 لوگ جتنے بھی ہیں پارلیمنٹ میں، سینیٹ میں، دونوں میں ملا کر کے، شاید صوبوں والے بھی آ جائیں اس میں، وہ صرف کر سکتے ہیں. یہ ٹوٹل آرگیومنٹ ہے یا کوئی اور بھی بہتر آرگیومنٹ ہے اس کے علاوہ؟ یا تو آپ کہیں کہ سارے فیصلے 184(3) کے درست ہیں، یہ تو پھر میں آپ کی بات مان لیتا ہوں، حتمی ہو گئے، ختم ہو گئے، چھوڑ آگے بڑھتے ہیں. یا کہیں غلط بھی ہیں.
یور آنر جو پبلک امپورٹنس کا لفظ استعمال کیا گیا ہے وہ 184 میں استعمال کیا.
سارے فیصلے درست ہیں یا غلط ہیں؟
میں اسی فیصلوں کی بات کر رہا ہوں. پبلک امپورٹنس کا فیصلہ ہونا چاہیے. میں یہی عرض کرنا چاہ رہا ہوں، مفاد عامہ کا فیصلہ ہونا چاہیے.
جواب ہی نہیں دینا چاہ رہے ہیں.
میں تو اس کا جواب مفاد عامہ کا فیصلہ ہونا چاہیے، مفاد خاصہ کا فیصلہ نہیں ہونا چاہیے خاص لوگوں کے لیے.
جو آپ نے
خاص لوگوں کے لیے
پڑھا ہی نہیں. ججمنٹ رپورٹڈ ججمنٹ جو ہیں آپ کے خیال میں سارے درست ہیں؟ آپ اس پہ جواب ہی نہیں دینا چاہتے؟
میں نے کافی پڑھی ہیں، کافی حد تک درست ہیں، اس کو میں ڈیفینڈ کرنے کے لیے بھی تیار ہوں.
ٹھیک پھر تو یہ کہہ دیں سارے درست ہیں. بالکل سارے درست ہیں، صحیح ہے.
اب شاید میری نظر سے کوئی وہ ججمنٹ نہ گزری ہو.
بس آپ کا موقف لے رہا ہوں.
یور آنر میں نے
حضور آگے پڑھیے.
میں یہ کلیم نہیں کرتا میں نے ساری ججمنٹ پڑھی ہیں.
ٹھیک ہے،
جو میں نے پڑھی ہیں اس کے مطابق میں ان کو صحیح سمجھا ہے. اور وہ انٹرپریشن جو ہے
اگر کل آپ باقی ججمنٹ جو آپ نے نہیں پڑھی آپ پڑھ لیں اور آپ اس نتیجے پہ پہنچے کہ وہ تو صحیح نہیں ہے، پھر کیا ہوگا؟
اگر وہ نہیں ہوگی تو اس میں جناب ریویو کا جو کانسٹیٹیوئنٹ جنہوں نے بنایا ہے انہوں نے ریویو کا رکھا اسی لیے ہے کہ اس کو ریویو کیا جائے. اب میں تو جناب اس میں سے وہ
آگے بڑھیں. دوسرا پوائنٹ کوئی ہے آپ کا؟
اچھا
دوسرے لوگوں کو سنیں نا، بہت ٹائم نہیں.
اس میں جناب میں وہ
قانونی اور آئینی بات کریں.
میں اسلام کی بات بھی کرتا ہوں. دین ہمارا جو سٹارٹ ہوتا ہے
کریے حوالے دیجئے.
میں دین جہاں سٹارٹ ہوتا ہے جب اللہ تعالیٰ نے انسان کو بنایا، جب اللہ تعالیٰ نے انسان کو بنایا تو فرشتوں نے جب اعتراض کیا تو اللہ تعالیٰ نے ان کا جواب دلیل سے دیا اور ان سے پوچھا کہ ہاں بھی ان کے آپ نام بتائیں. تو حضرت آدم علیہ السلام نے بتا دیے اور تمام نے سجدہ کیا الا ابلیس.
ایسے تو نہ کرنا، کوئی حوالہ دے کسی بات.
تو اللہ یہ کہ انہوں نے بھی دلیل اللہ تعالیٰ نے ان کے سامنے رکھی.
یہی تو ہماری بھی بات ہے.
تو یہ جو ججمنٹس ہیں ہمارے فیصلے وہ بھی دلیل پہ ہونے چاہیے.
اگر نہیں ہو
میں اسی کا کہ سٹارٹ ہی جو اللہ تعالیٰ نے فرمایا وہ دلیل سے فرمایا ہے.
صحیح ہے. اس
کے علاوہ اور بھی کئی اس میں قرآن میں حوالے ہیں جو دلیل پہ بات کی ہے. حالانکہ اللہ تعالیٰ فرما دیتے کہ جی میرا نالج ہے، کس نے انکار کرنا تھا.
ٹھیک ہے.
تو وہ جب ایک مالک ساری دنیا کا وہ دلیل سے بات کر رہے ہیں تو سب کو دلیل سے بات کرنی چاہیے.
یہ تو بات اپنے خلاف آپ کر رہے ہیں.
میں دلیل سے بات کر رہا ہوں جناب.
آپ کی بات نہیں کر رہا ہوں. آپ کہہ رہے ہیں کہ ایک دفعہ فیصلہ آ گیا تو حتمی ہے، چاہے اس میں دلیل ہو یا نہ ہو، حتمی ہے.
یور آنر ایک اپیل نیچے سے آتی ہے، آتے آتے ہم یہاں تک کتنے سالوں میں کتنی صدیوں میں پہنچتے ہیں.
پھر آپ یہ ادھر ایسی ڈسکشن کر رہے ہیں پھر اگلے کو سنتے ہیں. کوئی جنرل باتیں نہ کیجیے نا پلیز.
دوسرا جناب یہ ایک تو یہ اپیل کے بارے میں جناب میں نے عرض کیا.
آگے بڑھیے پلیز.
جی اچھا 184 اور 185 دونوں میں کہیں سبجیکٹ ٹو لا اور سبجیکٹ ٹو کانسٹیٹیوشن نہیں کہا گیا ہے، نہ 184 میں یہ بات ہے اور نہ 185 میں. اور یور آنر یہ جو انہوں نے اختیار دیا ہے کہ یہ کمیٹی بنے گی اور کمیٹی جو ہے اس کا فیصلہ کرے گی، آئین یہ کہتا ہے یہ اختیار جو چیف جسٹس کو دیا گیا وہ پوری سپریم کورٹ نے دیا ہے. رولز بنا کر رولز کے تحت یہ چیف جسٹس کو اختیار دیا گیا ہے. اگر چیف جسٹس صاحب اس اختیار کو کرٹیل کرنا چاہتے ہیں تو بہتر ہوگا کہ وہ اسی سپریم کورٹ کے پاس جائیں، کمیٹی میں بیٹھیں اور وہاں پر فیصلہ کروا لیں 2 کا جی کہ 2 کریں گے.
صحیح ہے، ٹھیک. بس جی اگر یہاں پڑھ کے تیاری کریں گے تو ہم نہیں سنیں گے. نیکسٹ آپ ایسے نہیں ہوگا نا، آپ سمجھ رہے ہیں بس ہم کیپٹیو ہیں جو
میں بالکل مختصر عرض
تو کر دیجئے نا، پڑھ کے اب سوچ رہے ہیں جلدی بتائیں نا
پوائنٹس میں نے لکھا ہے جو میں
ہم پڑھ لیں گے. اگر آپ نے اس میں ایک لفظ لکھا ہے اس پوری ایک کاغذ کی آپ کی درخواست سے ٹوٹل
2 صفحوں کی
چلیں 2 مان لیے.
اچھا یہ جناب وہ جو یہ بار بار یہ جو اس کا لوکل اسٹینڈ بائی کی بات کی جا رہی فنڈامنٹل رائٹس کنسرن فری جو ہے، تو اس کے بارے میں صرف ایک لائن میں جواب دینا پسند کروں گا کہ میرا رائٹ ہے کہ ہر کام قانون اور آئین کے مطابق ہو.
چلیں سن لی. آئیے
اور ایونٹ پوچھنا چاہتے ہیں سوال تو میں حاضر ہوں.
سر میں کانسٹیٹیوشن پٹیشن نمبر 6 میں ہوں، نہ پٹیشنر ہوں نہ رسپونڈنٹ ہوں، جماعت اسلامی کی طرف سے ہوں اور صرف نوٹس آیا پارٹی کو. تو اس
اگر آپ اس کو اپوز کر رہے ہیں قانون کو پھر سپورٹ والے بعد میں سنیں گے. آپ جگہ دے دیں پلیز. سپورٹ والوں کو سپورٹ والے بعد میں سنیں گے اٹارنی جنرل کے ساتھ. جی آپ کر چکے ہیں. کوئی اور رہ گیا؟ آئیے ادھر سے. کون نہیں آپ اس دن چلے گئے تھے. پلیز ڈونٹ انٹرپٹ. اٹارنی جنرل will you lead the arguments or will you respond to the arguments?
Yes, I will respond, my lord. Mr.
Sir, this is very unfair. My lord the Chief Justice, this is very unfair. آپ نے کہا تھا کہ اٹارنی جنرل صاحب کو آرگیو کرنے دیں، ہم آپ کو بعد میں سنیں گے. اب آپ
دکھائیے آرڈر شیٹ دکھائیے.
جی دکھائیے. This is very unfair. I will not argue if you don't want to hear me. But don't put things which are factually incorrect.
ویسے اگر کوئی بات کر رہے تمیز سے کوئی حرج ہوتا ہے؟ ویسے
نہیں سر، آپ اپنے اسلوب کو دیکھیے. آپ اپنے اسلوب کو دیکھیے پھر آپ ہمارے متعلق بات کیجیے.
دیکھ لیتے ہیں.
آپ کا اپنا اسلوب ٹھیک نہیں ہے. خواجہ طارق رحیم صاحب نے اسی واسطے آ جانے سے انکار کر دیا کیونکہ your lordship was very unkind to him.
Please don't argue on behalf of those who are not present.
Sir, he is my colleague. He has instructed me to inform you this.
سن لیجئے، یہ سب ججز نے سائن کیا ہے. Mr. Imtiaz Rashid Siddiqui, representing the petitioner in Constitution Petition number 6 of 2023, who was partly heard on the last date of hearing, states that he does not want to add anything further and that his written submissions may be read.
کون سا آرڈر ہے؟
Thank you very much. Now please take your seat.
Mr. Zaid Ibrahim,
I must lodge my protest.
Please take your seat before I issue something. Please take your seat.
Mr. Zaid Ibrahim, followed by Mr. Salahuddin.
It's as you wish. If you want to go last,
I'll go last, my lord.
As you wish. Everybody who comes, please introduce themselves. Who are they for?
I'm representing PMLQ.
Have you filed anything?
Yes, my lord. I filed CMA 3991 of 23. I'll be very brief, my lord.
3991
of 23. My lord, I'll be very brief and to the point.
Take a second, just let us get it out. CMA.
What is CMA number, right, sir?
My lord, 3991. May it please your lordship. We've heard
Do we need to have it before us or we don't need to have it before us?
My lord, if I do, I'll sort of, to a very limited extent, I'll refer to that later. If I may just address, my lord, that we are trying to understand the various meanings hidden within the few articles of the Constitution. In order to do so, the basic rules of interpretation, which according to this honorable court are to be utilized in reading and understanding these provisions. First, let us just identify that. How are we to read these articles? My Lord, the Honorable Supreme Court in the Sui Southern Gas case, 2018 SCMR 802.
802.
802, my Lord. The court summarized.
Have you given a paper book or something with these?
My Lord, ये तो judgments.
Judgments.
Judgments की मैंने I'd given the list. I'd given the list in the morning.
Okay.
Yeah, you mentioned it in paragraph 3 of your CMA. In the case of Sui Southern Gas.
My Lord, because
you have reproduced.
I want to read just one sentence from the judgment.
Relevant page?
My Lord, relevant page is at 830.
830.
830. What the court did here was it looked at all the case law, it looked at all the treaties from A.K. Broi Saab's to Justice Fazl Karim's to Servai Saab's, and it summarized the rules on how we are to interpret Constitution. And my Lord, those rules are summarized on page 830. A through I.
830.
I will not read all of those, but on the next page, 831, the Supreme Court cites with approval a judgment, and that is at paragraph 14b. Uska ek, that sentence really encapsulates how we are to read these provisions. My Lord, paragraph 14b. It's an Indian Supreme Court case which has been cited, and it says, the cardinal rule of interpretation, however, is that words should be read in their ordinary, natural and grammatical meaning subject to a rider. First rule is cardinal, ordinary, natural, grammatical meaning, subject to this rider. My Lord, I'm reading from 14b, paragraph 14b. Subject to a rider. That in construing words in a constitutional enactment, conferring legislative power, the most liberal construction should be put upon the words so that the same may have their effect in the widest amplitude. This is the basis on which we are to interpret these provisions of the Constitution. My Lord, with regard to entries,
Mr. Ibrahim, this principle is applicable in all eventualities?
My Lord, that is what this judgment says. And I'm just setting out the basic rule that the Supreme Court has set out. And then, my Lord, at page 838,
there is absolutely no departure from this.
No, obviously, my Lord, we make departures when we are reading and in trying to interpret. But a basic rule is set out. First of all, you determine what are the rules of the game on how do we read these provisions. And one of the rules that it says...
You see the situation which has arisen out of the proceedings which have been going on, whether this en bloc interpretation is applicable?
In my view, yes.
This how come?
In my view, yes. And I'll come to that. My Lord, on page 838, entries of the legislative lists on how they are to be read are also, the rules on that have been summarized. And if we see 838, the rule set out in paragraph 2, in construing the words in an entry conferring legislative power on a legislative authority, the most liberal construction should be put upon the words. 3. While interpreting an entry in the legislative list, it should be given widest possible meaning and should not be read in a narrow or restricted sense. 4. Each general word in an entry should be considered to extend to all ancillary or subsidiary matters which can fairly and reasonably said to be comprehended in it. My Lord, if we read these provisions, now coming to the matter at hand, my reading in relation to the practice and procedure part of this law, I'm not referring to the appeal part, the practice and procedure part. My Lord, the legislative competence, in my view, arises from Article 142A, where the Parliament can make exclusive power to make laws in respect of matters in the legislative list, federal legislative list. From Article 142, I look at the federal legislative list and I look at entry 58. Entry 58, matters which under the Constitution are within the legislative competence of the Parliament or relate to the Federation. Matters which under the Constitution are within the legislative competence of Parliament.
You see, if you
what are the matters?
Go by that argument, then there is no need for any other entry in the legislative list. Just this one article, this one entry would cover everything.
With, if I may answer your Lordship's question, that does this provide then complete free hand? No. It is only to the extent, the language is very clear, sir, and it's not all encompassing. It says matters which under the Constitution are within the legislative competence of Parliament. What is within the legislative competence of Parliament? Article 191, and this is where subject to law comes in, and the reading of that provision. So what I'm doing is,
what do you mean by, Mr. Zahid?
My Lord.
Entry number 55 is not applicable here.
No, entry number 55 is also. Because, I'll come to that. Because entry number 55...
The legislation has been made in both entries.
In both, yes. Yes, and I will come to that.
Mr. Zahid Ibrahim, what is then your argument in relation to the judgments which have been cited?
Yes.
That subject to the Constitution and subject to the law as mentioned in Article 191 is a restrictive provision. It is not a provision which confers jurisdiction or confers powers. It restricts. What's your response to that?
Can you please do respond to the queries, but can you just complete your thought, because my pen has been left in the air. I don't know what you're going to say next. Suspense is killing me.
Your Lordship's observation.
Respond to them.
Because I will respond to it because I have. I will refer to Justice Anwar Bhinder's case and try to express my view on this for your Lordship's consideration. So what I was saying is that in 142, entry 58, entry 55, and then you look at Article 191, where subject to the Constitution and law, Supreme Court may make rules regulating the practice and procedure of the court. Now, the argument being made by those who are challenging this law are saying that once the Supreme Court has made rules, then the door closes. Then there is no subject to law. You cannot do this. My submission to this Honorable Court on that will be that this court in Justice Anwar Bhinder's case has said the opposite. In Justice Anwar Bhinder's case, where it was looking at Article 188 there, the power to review. What did Justice Anwar Bhinder's case hold? My lord, this is PLD 2010, Supreme Court 483.
Which paragraph do you...
My lord, there are two paragraphs in this, my lord. First, I would like to refer to page 523, 522 and 523. My lord, paragraph 25. After reproducing Article 188 of the Constitution, where Supreme Court is been given the power subject to provisions of any act and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it. Paragraph 25 says, a bare perusal would reveal that it has been couched in a very simple and plain language, hardly necessitating any scholarly interpretation. It inter alia provides that the Supreme Court has power to review its judgment or order subject to the provisions of any act of Parliament and any rule made by the Supreme Court itself. The contention whether the Supreme Court rules are subservient to the Constitution have been discussed in a later part of this judgment. Now this, my lord, the next sentence is critical. Critical. It says, it is to be noted that no act of Parliament whatsoever has been promulgated, and thus it can reasonably be inferred that legislator does not want to restrict or impose any condition on the powers conferred upon this court under Article 188 of the Constitution. In fact, the word subject to provisions of any act of Majlis Shura and any rules made by the Supreme Court are indicative of the fact that indirectly the powers so conferred have been enhanced, and there was absolutely no intention for curtailment of such powers conferred upon this court under Article 188 of the Constitution.
This is what it is being said, that because you see, if you read on in paras 36, 37, the discussion is that even the power of the court is to enhance the power. It's not to curtail it.
My lord,
you can't just pick one sentence out of it.
But at least one sentence we have to read also.
you can't read one sentence when the context is provided by the immediately following sentence. How can we read a judgment?
I'm not seeking that.
आप आगे जाके पैरा 36 तो पढ़े ना, 36, 35, 36.
सर मैं पैरा 36 भी पढ़ लूंगा. मेरा सिर्फ ये कहना है कि जब सुप्रीम कोर्ट ये कह रही है,
एक जुमले से तो बात
नहीं जरूर.
Let me come back to.
आप अपना आर्गुमेंट तो कंप्लीट कीजिए.
आर्गुमेंट प्लीज कंप्लीट करें. Entry 58.
आपका आर्गुमेंट है क्या? मैं नोट करूं.
Let me come back to entry 58 first. आप कह रहे हैं कि matters under the Constitution which are within the legislative competence of Majlis Shura Parliament or relate to the Federation.
My lord.
This should be given the broadest possible meaning.
Yes.
And you relate this to the rules, well-settled rules of interpretation that you have already read up.
Yes.
And you relate this back now to law.
Yes.
As my learned colleague has already said, that this begs the question whether that is an enabling power. But my question is slightly different.
My lord.
जो rules of interpretation जो आप जिनका जिक्र कर रहे हैं और जिन judgments का आप जिक्र कर रहे हैं, as far as I am aware, those are concerned where the grant of legislative competence was by the entry itself. Okay? The grant was, that is the context in which those judgments are given. Okay? Now, as you are aware, an exclusive legislative list, whether federation or even the provinces, 35 Act, 56 Act, we don't need to go into that. An exclusive legislative list, especially now in the context of 73 Constitution as it presently stands, has two effects. One is positive. The legislative entry confers a power, a legislative competence, but the other is negative. The negative is that it excludes the other legislatures from making any such law. So if you look at it and interpret it in the broadest possible terms, which is the correct way to interpret these entries, it has two effects. It describes constitutionally what is the scope of the legislative grant that is being conferred positively. Negatively, it excludes the other. I put it to you that if 58, which does not itself confer any legislative competence, the effect and purpose of this is not positive but really negative. To clarify, to put it in the absolute clearest possible terms, that whatever power, legislative power, is given not in these entries, no, in the Constitution itself. Article 151, Article this, that, the number of judges of the Supreme Court, so many other examples can be given. That has, Article 58 is making clear, no intrusion by the provinces, none whatsoever. This is an exclusive grant to Parliament. So therefore, and I put it to you, that the way you are looking at it, it seems to me, with all due respect, and relying on those principles of interpretation, is perhaps not correct, because this is not a grant of legislative competence. It is merely shielding a grant made elsewhere, outside, other than on the legislative lists. It is shielding that from any possibility of encroachment by the provincial legislature. So that is its true purpose. What would you say to that?
जाहिद साहब, इससे पहले कि आप यकीनन इनके हमारे मोहतरम दोस्त का जवाब दें सवाल का, मगर मेरा फिर कलम हवा में रह जाता है। आपका अगर मैं एक दफ़ा लिख लूँ आपके पॉइंट क्या है, फिर ज़रा मुझे समझ आएगा, फिर बेहतर आप जवाब भी दे सकेंगे। ज़रा आप अपनी बात कंप्लीट कर लें, फिर जवाब ज़रूर दीजिएगा, नोट कर लीजिए।
So the point I was making, that yes, you read this entire judgment together.
Proposition बता दें।
Proposition is
अपनी proposition दें, judgments, you know this is the full court. आप अपना व्यू हमें दें, आपका व्यू क्या है?
My lord, मेरा व्यू ये है कि जस्टिस अनवर भिंडल्स केस में सुप्रीम कोर्ट ने ये फैसला किया है 188 को इंटरप्रेट करते हुए कि चूंकि पार्लियामेंट, जहां सब्जेक्ट टू लॉ लिखा है, क्योंकि पार्लियामेंट ने कानून नहीं बनाया है, उसका ये मतलब नहीं है कि रूल्स विल कंटिन्यू टू होल्ड द फील्ड एंड देयर कैन नॉट बी एवर एनी लॉ. माय submission is, my reading of Justice Anwar Binder's case is that this case itself acknowledges that Parliament has not made but can make law. That is my.
Are you saying that the judgment is interpreting legislative competence through subject to law and constitution? So where in the judgment exactly does it say subject to should be read as enabling granting legislative competence?
So, my ladyship, all I am saying is, because justice in this case, again the issue was that there was no law. There was made by Parliament in relation to, for instance, abhi jo review of judgments ka law aaya tha and which has been struck down. All I am saying is that the court, when looking at Article 188 at that time, all it was saying is, listen, there could have been a law, there isn't, but we are not trying to say that there can never be.
But please look at the wording of 188. It's very different from 191.
Exactly.
It doesn't say subject to. एक second ना जी, आप कह रहे हैं subject to the constitution and the law को हम enabling पढ़ें as a source of legislative competence. And you want us to rely on the Anwar Bhinder case in pursuance of this point, which is reading an article which does not say subject to. It is an article which actually says the Supreme Court shall have power subject to the provisions of any act of Majlis-e-Shura. It is saying that that act of Majlis-e-Shura and of any rules made by the Supreme Court. So there is a difference. This is a question that we've been working our way around, that what's the difference between an act of Majlis-e-Shura and the law. There is a difference. When you read subject to the law as an enabling provision, you bring in that executive action like an ordinance. You bring in that many other forms. So you're saying that the Supreme Court rule-making power becomes subservient to all those sources of law that exist, that the Constitution recognizes as being part of the law. So hence, can you explain through this judgment how that helps your point?
My Lord, my Ladyship, first of all, when we say law, it certainly includes an act of parliament. And I acknowledge that 188 is different from 191. In 188, in fact, the Supreme Court has been given the power of review. In 191, there is no power. There is only acknowledgement that Supreme Court may make rules.
There is a power
the language is
given to
different.
The Supreme Court. It's
My Lord, the language is different.
Power conferring article which empowers the Supreme Court to make rules, and then a judgment of this court again. It's I think in the NRO judgment which says rules framed under constitutional powers, i.e. the 1980 Supreme Court rules, stand on a higher pedestal compared to ordinary legislation. What does that mean?
If I may, with utmost respect, I know your Lordship in the Ghulam Mohiuddin case recently rendered judgment where the Supreme Court review law was held to be illegal. Your Lordship has expressed exactly that point.
No, this is not our expression. That is a reliance on an earlier judgment of this court which says this.
My Lord, all I was trying to point out that the language of 188 and 191 in granting powers to the Supreme Court uses very different languages.
But you see, even this judgment that you're relying on, this also says that the Supreme Court rules are on a higher pedestal and promulgated on the basis of a mandate given by the Constitution.
Thank you.
Exactly यही कह रहा है.
Thank you for pointing out. Let me again, in relation to this judgment also, now clarify what this judgment has actually said and what it is purportedly argued that it has said.
No, argument apart, as Ladyship also pointed out, and as has been mentioned earlier, the judgment that you rely upon in itself lays down the ratio of the judgment is that the rule-making power, when exercised, when the rules are framed, then such rules stand on a higher pedestal for the reason that those rules have been framed in exercise of powers granted by the Constitution itself. And the powers granted by the Constitution under 191 are the powers granted by the Constitution to the Supreme Court and not to any other organ of the state.
My Lord, if we can just see page 536 of this judgment on this point alone.
Before you come to 536, just one quick question. This sentence that you have read out to us from page 523,
yes,
which you regard as critical, is it your understanding that this is part of the ratio of the judgment?
Yes.
This is para 25 head note K जो है ना आपका इसमें पढ़े नहीं. In fact, the word subject to the provisions of any act उसको define किया इन्होंने.
जी सर, मैं
बिंडर वाले केस में.
हाँ, मैं एक सेकंड.
जाहिद साहब आप चले आर्गुमेंट तो अपना करें ना.
जी. So I was trying to yes, page 536 of the judgment, my Lord, of the same judgment.
Mr. Zahid,
जी पढ़िए
Para 36 is more relevant.
सर मैं उसी पे आऊंगा सर, अगर एक सेकंड के लिए। ये हायर पेडेस्टल वाली जो बात है,
जी
530 पेज 536 पे फर्स्ट पैराग्राफ, the Supreme Court rules are on a higher pedestal and promulgated on the basis of mandate given by the Constitution itself and not by a government, object whereof was to enhance the power of review as conferred upon the Supreme Court under Article 188 of the Constitution. One more time, just the first part. Supreme Court rules are on a higher pedestal. Higher pedestal than what? ये इसके जो प्रीसीडिंग पैराग्राफ, प्रीसीडिंग पेज है, अगर हम उस पे जाते हैं,
इसलिए कहा है कि रिव्यू में पावर बढ़ाए में रूल्स ने
सर इसमें ये
I'm trying to understand, Mr. Zahid Ibrahim. Please, can you complete your thoughts? Take the questions, note them. You keep responding to every query. I don't know what you're going to say next.
Okay, my lord. All I was the point.
You were on 236 AA.
The point that I'm making is that in this judgment, when the Supreme Court says that the rules are on a higher pedestal because they are made under constitutional sanction, what are they saying? Higher pedestal than what? Higher pedestal than law or something else? They are saying higher pedestal than rules made on the basis of another statute.
No, no, no.
And if I may just complete, I will complete.
If you would also read the NRO judgment, this point has further been elaborated by this court by saying once these rules are made, any subsequent legislation we may not follow. And we need not follow.
मेरी सिर्फ आपसे ये गुजारिश है कि यहाँ पे जो कंक्लूजन हुआ है फुल कोर्ट का in relation to the Supreme Court rules being on a higher pedestal, that is not on a higher pedestal as compared to any law. And the reason why I say this is evident because this discussion started from page 500.
Can you just complete your thoughts?
Page 534 at the bottom of page 534.
Para 37.
Para 37, my lord. Exactly.
Zahid, para 36 is very important.
Zahid Sahab, please argue करिए as you want.
So para 37 का ये
Zahid Sahab, अगर मैं आपसे सवाल ऐसा पूछूं जिससे मैंने फैसले ही कर रहा हूं तो आप कहें फिर सवाल ही नहीं बनता है, आप अपना आर्ग्यूमेंट कर लें कंप्लीट, फिर हम आपसे सवाल पूछ लें.
I mean, I honestly feel that I'm trying to answer questions.
आप पहले आर्ग्यूमेंट अपना कंप्लीट कर लें ना.
They help in this debate. So I was just wanting to read para 37 from the bottom. मतलब जो in Roman font है उससे पहले वाला एक sentence. A line of distinction. In this regard, reference may be made to the case of Federation of Pakistan, Saeed Ahmed, PLD 1974. A line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of Constitution as conferred upon it by Article 188 of the Constitution. ये जो sentence है, my lord,
a line of distinction.
A line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of the Constitution as conferred upon it under Article 188 of the Constitution. That is what is being...
Ajay, can you now go back to 536 AA?
If this line of distinction is drawn, Mr. Zahid Ibrahim, if this line of distinction is drawn,
yes,
that which means that the rules made under 188 are of a different category altogether, then there's no need to say that those rules are at a higher pedestal. Then those rules and rules made which are normally called subordinate legislation fall into two different categories. It seems to me that the passage, that those words that you have just read out from page 536 on a higher pedestal is not vis-a-vis a category that the Supreme Court, in the words that you have just read out,
My Lord,
say fall into a totally separate and distinct category. And if this is correct, then the higher pedestal can surely be only vis-a-vis law and not subordinate legislation or rule-making power, which is of a totally different nature. Would that not be a proper reading of the judgment as a whole?
Your Lordship is saying, Supreme Court itself says, in view of the above discussed principles of interpretation, it seems immaterial to discuss whether the Supreme Court rules are subservient to Article 188 of the Constitution. That is an immaterial argument. Where it draws a comparison and says that they are on a higher pedestal, that is only in relation to rules made under some other statute. That is the point. My Lord,
and if we go back to 536AA, now if we are to read this line disjunctively, object whereof was to enhance the power of review as conferred upon Supreme Court under Article 188 of the Constitution, then if you go to read it like the petitioners want us to read it, that would mean that the Supreme Court is now bound by Article 188 either, because it's giving it more power than the Constitution itself. Surely that cannot be the case. So it has to be read in context to the line that you've read. I don't know.
I understand that, we are all pressed for time. I don't want to sort of...
I'm पढ़ लेंगे पूरा judgment.
My Lord, the next point I want to make is in relation to the appeal.
But before you go to appeal, what do you say about entry 58 on which you rely upon? That entry 58 is, since it is not conferring legislative competence, the rules that you rely upon, rules of interpretation, the purpose of entry 58 is the negative aspect of those rules, to make sure that a competence given elsewhere other than the lists, that is totally outside the scope and power of provincial legislature. That's all that the purpose of 58 is. It does not confer legislative competence, and therefore the principles that you rely upon really don't apply. What would you say to that?
My response to that would be that...
Zaid Sahab, बहुत अच्छा सवाल है. Shall we take the break now, and you have received a number of queries, just mull them over, but then you just be precise in your answers, because we will hear you, don't worry. So we can take a slightly longish, make it this lunch break as opposed to 1:30 and the prayer break or whatever you want to make it. Just make these questions are very valuable for food for thought, and then mull them over and respond to us.
I promise.
We will just come back in half an hour. Is that all right?
I promise to continue, but I can't promise to be able to have all the answers to the questions posed.
You've seen what's been happening these last few days.
Yes.
You should be ready for that.
I've tried, my Lord.
आप लोग भी जरा repetition ना कीजिएगा, कोशिश कीजिएगा, नए बातें कीजिएगा जो इन्होंने नहीं की हैं. चलें, ऐसा होगा.
रेलिवेंट पेज कौन सा अभी
सर सॉरी मेरी किताब जरा नहीं मिल रही, लेकिन 73 सुप्रीम कोर्ट पेज 49 with a bit delay, but just
पढ़ लेंगे बाद में, अगर आपको नहीं मिला कोई बात नहीं, आगे बढ़ते हैं.
My lord, and the relevant portion, my lord, will find at page 69, sir. It refers to 68, the case of Fazlul Qadir Chaudhry, sir.
First paragraph.
Para 69, sir. And it says this the whole page.
Para 69?
Page 69, my lord.
जी.
जी.
कहाँ से पढ़ें?
जी.
कौन सा पैराग्राफ?
जी पैरा डी, जहाँ parenthesis डी पैराग्राफ से what the Honorable Supreme Court was saying. So far, therefore, as this court is concerned, it has never claimed to be above the Constitution, nor to have the right to strike down any provision of the Constitution. It has accepted the position that it is a creature of the Constitution, that it derives its power and jurisdiction from the Constitution, and that it will even confine itself within the limits set by the Constitution, which has taken oath to protect and preserve. But it does not claim that, and has always claimed that it has the right to interpret the Constitution and to say to what a particular provision of the Constitution means or does not mean, even if that particular provision is a provision seeking to oust the jurisdiction of this court. This is the right which it acquires not dehost the Constitution by virtue of the fact that it is a superior court set up by the Constitution itself. It is not necessary for this purpose to invoke any divine or supernatural right, but this judicial power is inherent in the court itself. It flows from the fact that it is a constitutional court and can only be taken away by abolishing the court itself. In saying, however, I should make it clear that I am making a distinction between judicial power and jurisdiction. In a system where there is trichotomy of sovereign powers, then ex necessity derive from the very nature of things, the judicial power must be vested in the judiciary. But what is this judicial power? Judicial power has been defined in corpus juris secundum. The judiciary or judicial department is an independent and equal coordinate branch of government, and is that branch thereof which is intended to interpret, apply the law, or the department of government which is charged with the declaration of what the law is and its construction so far as it is written law. This power, it is said, is inherent in the judiciary by reason of the system of division of powers itself, under which, as Chief Justice Marshall put it, the legislature makes the executive execute and judiciary construes the law. Thus, the determination of what the existing law is in relation to something already done or happened is the function of judiciary, while the predetermination law shall be for the regulation of all future cases falling under its provision is the function of legislature. It may well be then asked at this stage as to what is meant by jurisdiction. How does it differ from judicial power? Apart from setting up the organs of the Constitution, may well provide for a great many things, such as the subjects in respect of which that power may be exercised and the manner of the exercise of that power. Thus, it may provide that the courts set up will exercise divisional or appellate powers, or only act as a court of secession, or only constitutional issues. It may demarcate the territories in which a particular court shall function, over which its writs shall run. It may specify the person in respect of whom the judicial power to hear and determine will be exercisable. These are all the matters which are commonly comprised in what is called the jurisdiction of the court. It expresses the concept of the particular rest or subject matter over which the judicial power is to be exercised and the manner of its exercise. Jurisdiction is therefore right adjudicate concerning a particular subject matter in a given case, as also the authority to exercise in a particular manner the judicial power vested in the court. In exercising this power, judiciary claims no supremacy over other organs of the government, acts only as the administrator of the public will. Even when it declares a legislative measure unconstitutional void, it does not do so because the judicial power is superior in degree or dignity to the legislative power, but because the Constitution has vested it with the power to declare is in the cases which come before it. It thus merely enforces the Constitution as a paramount law whenever a legislative enactment comes into conflict with it, because it is a duty to see that the Constitution prevails. It is only when the legislature fails to keep within its own constitutional limits, the judiciary steps in to enforce compliance with the Constitution. This is no doubt a delicate task, as pointed out in the case of Fazl Qadir Chaudhry vs. Shah Nawaz, which has to be performed with great circumstance. It has nevertheless to be performed as sacred constitutional duty when other state functionaries disregard the limitation imposed upon them or claim to exercise power which the people have been careful to withhold from them, sir. So this is the difference between jurisdiction and judicial power. The power exercised under 191 is a constitutional power vesting in this court to regulate the practice and procedure of the court, and Parliament cannot interfere in that because it's exclusively given. If it was that have said until the Parliament makes the law, the Supreme Court can make the rules of procedure, etc. These kind of words were not used. Where the Constitution specifically uses these words, then the law is being given. But it says subject to, that is implying there's not an enabling provision, it's a restrictive provision. This is my humble submission.
Anything else? Mr. Zubairi, the similar principle was reiterated in Sharaf Afridi's case?
That was regarding independence of judiciary, and that was separation of judiciary, PLD 94, Supreme Court, page 105.
Added note by Salim Akhtar.
Ji, sir. Yes. Ji. And it was coming from a larger bench of the Sindh High Court, 89 Karachi, page 404. That judgment was upheld, authored by my Lord Ajmal Miazi then was, sir. My lord,
I think if you argue in context of Pakistan and what's happening and why presumably the legislator enacted this.
I understand, sir.
No, you're not. Now let me pose a certain queries to you. This they are giving a right of appeal. Now we're talking about the right of appeal under 184(3).
My lord.
Correct?
Yes, my lord.
अब 184(3) में जो हक दिया गया है अपील का, आपने बिल्कुल ये बात नहीं करेंगे कि 184 कैसे इस्तेमाल किया गया है।
ठीक सर।
ठीक है, या तो कहिए बिल्कुल सही इस्तेमाल हो रहा है, या कहिए बिल्कुल गलत हो रहा है, या कहिए कभी सही हो रहा है कभी गलत। कुछ तो बयान कीजिए ना, क्योंकि आप तुम्हारे सामने पिटिशन नहीं लाए। मुझे समझ नहीं आ रहा है आपकी एंग्जाइटी क्या है इस लॉ से। वजाहत से बात कर दें तो हम समझ जाएंगे। अब अदर सवाल अभी तक आया नहीं है। 184(3) जो है ना का इस्तेमाल कैसे हुआ है पाकिस्तान में, हकीकत क्या है? ह्यूमन राइट्स सेल, कोई रूल में उसका तस्करा है बताइए, है किसी कानून में तस्करा है बताइए, है। अभी तो हम चलें पार्लियामान को तो छोड़ दें, हमारे अपने रूल्स में उसका तस्करा है। अब 184(3) जहां तक हेबस कॉर्पस की बात है उसका तो रूल में तस्करा है, मगर जो दूसरे इख्तियारात इस्तेमाल किए गए हैं 184(3) के तहत उनका रूलों में तस्करा था नहीं था, कैसे इस्तेमाल किया गया। और अगर आप कहते हैं कि रूल की भी जरूरत नहीं उधर, अब तो हम रूल से भी चले गए ना। 191 ये तो नहीं देता है इजाजत के चीज बना सकता है रूल, या ह्यूमन राइट सेल बना सकता है, या तो क्या ये है। तो वहां तो आप अपनी आंखें बंद कर रहे हैं। उसमें चलें, यहाँ तक बात मान लेते हैं कि अगर 184(3) में ह्यूमन राइट सेल बन गई होती, फिर आपकी बात में वजन होता कि भाई ठीक है 184(3) में ह्यूमन राइट सेल बन गई है तो उसके तहत कर लिया है, सही किया गलत किया तो बात की बात है। तो वो बातों को तो आप बिल्कुल नजरअंदाज करना चाहते हैं कि 184(3) में। अब देखिए, इससे पहले कि दुनिया हम उंगली उठाए, मैं अपने ऊपर उंगली रखता हूं कि 184(3) का इख्तियार जो इस्तेमाल किया गया है, और हजारों केसेस में कुछ केसेस की नौयत थी कि बिल्कुल वो एक जनरल पब्लिक इंटरेस्ट के आप मैटर में आप ला सकते हैं उनको, कुछ थे बिल्कुल पर्सनल हो गए थे केसेस। ठीक है, पहले आप हमें उस पर तो कोई तशरीह कर ही नहीं रहे, आप बता ही नहीं रहे कि कौन से रूल्स के तहत कर रहे थे। अब आप कह रहे हैं चले खैर सुप्रीम कोर्ट ने गलत नहीं, सुप्रीम कोर्ट के एक चीफ जस्टिस ने अगर गलत किया तो पार्लियामेंट को तो ये गलती नहीं करना चाहिए। तो कम से कम वहां ज्यादा वजन नहीं होगा कि वो तो कम से कम कानून के मुताबिक एक चीज करना चाह रहे हैं। यहाँ ये 184(3) का इख्तियार कैसे इस्तेमाल हुआ, भाई ये हकीकत है पाकिस्तान की। आप न्यू जर्सी ना जाइए, आप पाकिस्तान में रहिए और यहीं की बातें थोड़ी हम लोग कर लें। कैसे इख्तियार हुआ बता दें, ये आप बिल्कुल तरीक़ेकार सही, फिर बात सही है। अगर आप कहते हैं नहीं था तो फिर आप उसकी रेमेडी, अगर एक गलती होगी फिर उसकी रेमेडी तलाश करना किसकी जिम्मेदारी है? सबसे बड़ी जिम्मेदारी इस अदालत की है, इसके बाद शायद पार्लियामेंट की पड़ती है। अगर हमने गलती की हमें दुरुस्त करना चाहिए, अगर पार्लियामेंट ने गलती की है तो पार्लियामेंट को दुरुस्त करना चाहिए। अगर हम अपनी गलती नहीं दुरुस्त करते हैं तो पार्लियामेंट क्या कर सकती है? नहीं। आप बस सिर्फ उस बात पे खड़े हुए हैं, मगर जितनी वो जो पाकिस्तान में जो कुछ हुआ है उसको वो नजरअंदाज करें, चाहे वो प्राइस शुगर का तयन कर ले या कोई और बातों का कर ले। भाई वहां तो रूल्स बना लेते। एक ऑर्डर था मेरा कि भाई चलें रूल्स बना ले, फिर इसको हम कर लेते हैं। तो वहां तो आप जा ही नहीं रहे हैं। तो आपका जो कंडक्ट आ जाता है क्वेश्चन में कि आप एक पॉलिटिकल पार्टी को रिप्रेजेंट कर रहे हैं या पीटीआई को नहीं कर रहे हैं।
नो सर,
आप किसको कर रहे हैं?
नोटिस एज प्रेसिडेंट ऑफ द सुप्रीम कोर्ट।
आप सुप्रीम कोर्ट को कर रहे हैं जी। तो आपने वजाहत नहीं की कि आप किसकी। चलो खैर ठीक है। तो सुप्रीम कोर्ट का हमें बताएं ना मौक़िफ़ क्या। अच्छा, सुप्रीम कोर्ट बार एसोसिएशन का मौक़िफ़ क्या है कि 184(3) जैसे इस्तेमाल हो रहा था सही हो रहा था? तो फिर बता दीजिए ना। अगर हम इस कानून को खत्म कर देते हैं, कलकदम कर देते हैं, तो कल मैं उसका इस्तेमाल वैसे ही करता रहा हूं जैसे पहले हो रहा था, वो सही होगा? इसका जवाब दे दीजिएगा।
सब बिल्कुल मैं आपसे मुत्तफिक हूं इस बात।
मैंने कोई ये पॉइंट ऑफ व्यू नहीं दिया। मैं आपका समझना चाह रहा हूं। मेरे मुंह ना कही कि मेरा मौक़िफ़ है ये।
सर आपका मौक़िफ़ तो हम सुन चुके हैं कि आप
नहीं, मेरा मौक़िफ़ नहीं है।
आपने कहा कि जी आप अपने पावर्स गिव अप करना चाहते हैं, आपने कहा।
नहीं, ये वो अलग बात है। ये अभी बात हो रही है 184(3) की, प्रोसीजर वाली बात अलग है, वहाँ पावर की बात।
पहले मैं पूछा भी तो यहाँ 184 पे तो आया ही नहीं था। मैं आप
175 की जो बात हो रही है तो
मैं तो फिर फिर हो गए तो मुझे आने तो दें 184 पे। उस पर
कब आएंगे? 10:30 बज गए
सर। आप 11:30 तक से पहले मैं इंशाल्लाह खत्म कर लूंगा, लेकिन
आपको नहीं।
British Council English online courses for those who want to study abroad or who want to ace a job interview. British Council.
उस पर बहुत चीजें जिस पे बहुत सवालात उठे, लेकिन पॉइंट इज दैट बात मैं जो आर्ग्यू कर रहा हूँ सुप्रीम कोर्ट बार कि
आप एक फलसफाई बात कर रहे हैं।
नहीं सर,
हकीकत में वो नहीं है।
पहले मुझसे पूछा कि सही इस्तेमाल हुआ गलत, तो उसका जवाब
नहीं तो फिर उसका हल भी बता देना।
हल आ रहा हूँ ना सर, पहले वो बात बता रहा हूँ जो आपने मुझसे सवाल किया उस पर हल की तरफ आ रहा हूँ। मैं जो अर्ज कर रहा हूँ कि सर इसका सही इस्तेमाल हुआ गलत इस्तेमाल हुआ, देखना आपको ये है कि कॉम्पिटेंस किसकी है इसको सही करने की, जुरिसडिक्शन किसकी है।
नहीं देखिए ये बड़ी अच्छी बात है कि आपने अब अपनी जिम्मेदारी एकदम हम पे डाल दी। नहीं मैं आपकी राय पूछ रहा हूँ, तो आपने कहा देखना आपको है, आपकी कोई राय है, आप पाकिस्तान की सबसे बड़ी बॉडी है वकीलों की, तो बताइए ना, अपनी राय बताइए।
जी आबिद जुबैरी साहब। जी सर, इसी टेक्स्ट में अगर जो प्रैक्टिस एंड प्रोसीजर है एग्जिस्टिंग उसके तहत से 184(3) को ले, अगर वो फंडामेंटल राइट्स को वायलेट करता है, इट हैज द इफेक्ट ऑफ वायलेटिंग द फंड
said this in the first hearing. It is not a question of good, bad,
it is no competence, sir.
It is the question of
competence. Who is there to correct it, or who has to be here to make the law?
A law may be a very good law, but if somebody who is not competent to make it, it is in conflict with the constitutional powers, जिधर ट्राइब्यूनल ऑफ पावर्स हैं। आप हमें ये कॉम्पिटेंस पे बताइए कि किसकी कॉम्पिटेंस।
वो तो बात हम समझ गए, आपका मौक़िफ़ ये है, वो तो बात समझ गए, मगर मेरा सवाल इसका मतलब ये नहीं कि आप उसको नजरअंदाज कर लें सिर्फ कॉम्पिटेंस पे, तो वो आप बता दीजिए, उस पर तो हम सुनना चाहते हैं आपकी राय।
अपील के ऊपर आ रहा हूँ, लेकिन पहले मैं जज साहब का सवाल दे दूं। अतर मिनल्लाह साहब ने जो पूछा, माय लॉर्ड, माय आंसर इज दैट इट्स नॉट अ मैटर ऑफ गुड और बैड और गलती, इट इज अ मैटर ऑफ कॉम्पिटेंस। My Lord has to see, this court has to see whether they had the competence to even correct that thing by me.
Then what? ये इसके जो प्रीसीडिंग पैराग्राफ, प्रीसीडिंग पेज है, अगर हम उस पे जाते हैं,
इसलिए कहा है कि रिव्यू में पावर बढ़ाए में रूल्स नहीं।
सर इसमें ये
I'm trying to understand, Mr. Zahid Ibrahim, please can you complete your thoughts, take the questions, note them. You keep responding to every query, I don't know what you're going to say next.
Okay, my lord, all I was the point,
you were on 236 AA.
The point that I'm making is that in this judgment, when the Supreme Court says that the rules are on a higher pedestal because they are made under constitutional sanction, what are they saying? Higher pedestal than what? Higher pedestal than law or something else? They are saying higher pedestal than rules made on the basis of another statute.
No.
And if I may just complete, I will complete.
If you would also read the NRO judgment, this point has further been elaborated by this court by saying once these rules are made, any subsequent legislation we may not follow. And we need not follow.
मेरी सिर्फ आपसे ये गुजारिश है कि यहाँ पे जो कंक्लूजन हुआ है फुल कोर्ट का, in relation to the Supreme Court rules being on a higher pedestal, that is not on a higher pedestal as compared to any law. And the reason why I say this is evident because this discussion started from page 500.
Can you just complete your thoughts?
Page 534 at the bottom of page 534.
Para 37.
Para 37, my lord. Exactly.
Zahid, para 36 is very important.
चलिए Zahid साहब, please argue करिए as you want to.
Para 37 का ये
Zahid साहब, अगर मैं आपसे सवाल ऐसा पूछूं जिससे मैंने फैसले ही कर रहा हूं, तो आप कहें फिर सवाल ही नहीं बनता है। आप अपना आर्गुमेंट कर लें कंप्लीट, फिर हम आपसे सवाल पूछ लें।
I mean, I honestly feel that today, I mean, I'm trying to answer questions.
आप पहले आर्गुमेंट अपना कंप्लीट कर लें ना।
They help in this debate. So I was just wanting to read para 37 from the bottom. मतलब जो in Roman font है उससे पहले वाला एक sentence. A line of distinction. In this regard, reference may be made to the case of Federation of Pakistan, Saeed Ahmed, PLD 1974. a line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of Constitution as conferred upon it by Article 188 of the Constitution. ये जो sentence है, my lord,
A line of distinction.
a line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of